You're on now.
Yes, Your Honor. I have a 9:30. It's Capital One versus Bosquet, but I don't see anybody that has the name.
Is that defendant here?
No, Your Honor.
All right, I'm just going to go on to this case. This is called Matthew Haroni versus Adam Randall, DBA Tilchin and Hall PC, 2501675 RGC. All right, Mr. Haroni, your name?
Good morning, Matthew Haroni in pro per.
Ms. Ford?
Good morning, Your Honor. Corrine Ford on behalf of the defendant, Adam Randall.
So I was off yesterday and I had no idea how lengthy these motions, and I must have somewhere in the neighborhood, I don't know, could be wrong, but I got to have 300 pages here between motions and exhibits. I'm not even sure I know where to start. I'm not sure. I'm going to try to plow through this. But I honestly wish I would have had more time, to be honest with you. It was a lot to digest, and I did the best I could. I guess I'm going to start with your motion to strike the amended complaint. And I want to ask you, so do you want to start with that?
I think that makes sense, Your Honor.
Look, so I would agree with you from what I read. He did not file the amended complaint properly. Okay. But why not allow leave to file the amended complaint?
Well, at this point, if you're going to allow him to file leave to amend the complaint, then our motion for summary disposition is basically going to be moot.
Well, I understand that because...
So we'll have to refile that motion.
You're not telling me venue is improper here, though, right?
It is. Mr. Randall does not live in Wayne County. He does not work in Wayne County.
Well, doesn't he work?
In Oakland.
Wait a minute. Doesn't he work in Wayne County if he does conduct business here? He's representing a condominium association.
He does represent a condominium association that is Wayne County, but he lives and works in Oakland County.
I know, but it's still one of the prongs is resides or conducts business, right? Does he not conduct business in Wayne County? I mean, if you want to say, Judge, I think that the venue is proper, but for the convenience of witnesses and parties, I'm going to order that I'm going to ask you to transfer the case. You're going to have to tell me why it's more convenient for a case to be transferred to another court when all the witnesses, if any, are here. I mean, where are all the witnesses? I mean, you can't say, you agree he conducts business here, right? That's one of the prongs.
Correct.
Okay, so venue on its face is proper. The only way to do it is say for the convenience of parties and the witnesses that it's more convenient to be in another jurisdiction. So if you're going to tell me that I'm wrong, you can tell me I'm wrong. Judge, here's why I think you're wrong, and I'll be glad to listen to that. Let's start with that aspect of this.
Well, I think that is going to actually depend on if he's allowed leave to file the amended complaint and which claims, if any, survive after we refile a motion for summary disposition. Then it may be dependent on what witnesses need to be called. Because if all of the claims are against Mr. Randall may be the only witness other than Mr. Haroni and his wife.
Well, that may be, but look.
I mean, the venue argument goes, I mean, that's in regards to the motion for summary disposition. So if you're going, I mean, so I don't know if that even needs to be decided today.
Well, it doesn't, but you probably should have filed a motion to change venue if you were serious about it, rather than just saying venue is improper. in your summary disposition motion, right?
Okay. Understood.
Sir, I read some of this, and I read it. When I say I read some, I read a lot of it. It's, let me just pull out something here. Give me 1 minute, please. This was a lot to try to digest. What she's saying when she says you're not the real party in interest is that any of these fees, any claims under the Fair Debt Collection Practices Act must fail because you're not the one that was assessed the fines. Is that not your argument, Ms. Ford?
It is to a point, and also there were no debt collection actions taken. So at all. So I mean those claims don't even apply.
So you're not really the real party in interest here on most of these claims. I mean, look, you do what you want. If you want to do this, that's fine. And I'm not trying to discourage you, sir. I'm yet to see anybody do this competently. I'm yet to see any improper party, maybe one or two in my 30 years here. Now I know there's a lot of things on the internet now, and we can pull things up and read them and think we understand them, and maybe you understand them better than I think you understand them, or understand them better than almost any improper party can understand them. I don't see a real good claim here, sir, to be honest with you. From what I've read, I could start over and simply strike the amended complaint. I could do that. Because you improperly filed it. It's late. You only have 14 days. You can't just start filing complaints, amended complaints after that time period with no leave from the court. Now, I'm going to talk, and I'm going to say to you two this. Is there a way the two of you think you can be civil and go into a breakout room and talk about this or not? If you can't, I understand. It's okay. That's why I'm here.
Yes, Your Honor, I can.
I'm sorry?
Yes, Your Honor, I can.
Do you want to try, Ms. Ford? See if you can resolve it right now before everybody spends a lot of time and a lot of money. It's not, and I'm not referring to myself. I'm referring to your client and you and Mr. Haroni. And maybe there's a resolution. I don't know what it would be, but maybe you can try. I'm telling you, sir, I don't know how any of these acts constitute slander. I mean, I suppose if they're, or libel rather, I suppose if they're defamation, I suppose if there were untruths that were stated, falsehoods that were stated by a lawyer, and it harmed the reputation of somebody, on that count, you might very well be the real party in interest. But what he was doing was communicating with your spouse by letter and saying, these things can't go on, they violate the bylaws. And go ahead.
Respectfully, we don't agree that we ever broke any bylaws. And
I'm not saying you did. I don't know if you did or not. I mean, there's a lot of things in here about recording devices and cameras, and that would, on my reading so far, would be a violation. Look, I'm kind of rambling here. Do you two want to go into a breakout room and see if you can resolve it? If you don't, I understand.
Yes, sir.
We can, Your Honor. Just one more thing, though, before we do that, going back to the motion to strike the amended complaint, there was another part to that motion, and that was to seal Exhibit 22. That was involving the documentation that Mr. Randall submitted in response to a complaint that was filed against him by Mr. Haroni and the Attorney Grievance Commission. So that's a confidential process. So we would ask that exhibit be sealed.
And that's Exhibit 22.
Exhibit 22 to the amended complaint.
Yeah. Why don't you two, I'm going to take that up, and I tend to agree with you. I'm going to take that up. Why don't you two go into a breakout room right now and see what you can resolve, if you can resolve it. If not, come on back in. If it breaks down, I'll call your case immediately, okay?
All right. Thank you, Judge.
Thank you. I want to make sure. I want to see Exhibit 22. Tabitha. Jennifer, do you?
Yes, Judge.
Hang on. Okay. I got it. Do I have anything else ready?
Wait, this is not on record.
Let's do it. Is any other civil case ready, Jennifer?
And Judge, I have two parties in the breakout room on one.
Fine.
And
Okay, I'm going to do this signing on record real quick. Donald Allen Bankovich, 25G716663. Good morning, Detective. Your name?
Morning, Your Honor. Harry Robinson, Toronto Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self. You got it.
I do.
Okay, go ahead.
On 6/19/2025, Officer Sergeant Seifert responded to GBY Arena for a disturbance. During his investigation, he found that Donald Vankovich was attempting to load up a boat that he was purchasing. The boat was too large for the trailer, and further investigation realized that the trailer was not his. He didn't have a trailer. He grabbed a random trailer in the boatyard attempting to load on this boat that he was purchasing. He admitted to the officers that he planned on using that trailer, which was not his. He had no permission to use to transport his boat. During the incident, he did destroy the boat also, or did destroy the trailer. The trailer is no longer usable.
And what was the value of the trailer?
So I have some quotes between $6,000 and $11,000. Three different quotes from Mr. Simonkevich. He was the owner of the trailer.
Based on your sworn testimony, I find that the crime of larceny, 1,000 or more, but less than 20,000 was committed. There's probable cause to believe the crime was committed by the defendant. You already signed the complaint. Court is signing and dating both the complaint and the warrant for the arrest of the defendant. Anything else?
Thank you, Your Honor. He's actually here for a PCC next door at 9:45.
Okay.
Can I
Yeah.
possibly have Judge Simpson arraign also?
Well, I mean, I'm supposed to arraign.
Oh, okay, yeah.
I
I assume he's in custody here.
I don't know if he is or not. Did I set a bond on him already that he couldn't post?
Yes, it was 50,000, 10% with a tether. We called yesterday. He was still in the county.
Yeah. So if he's here, we can get him a lawyer and I'll arraign him now.
Oh, cool.
Okay.
He's not, okay. Thank you very much.
Thank you. I'm going to take a 5-minute recess and come back then. Okay, thanks.
I'll also look at that. Yeah, I know, right? Thank you. Have a good one.
What's that?
I said, thank you. Have a good one.
You too.
Ms. Ford, Judge just stepped off for 5 minutes. He'll be right back.
Okay. Thank you.
You're welcome.
Mr. Haroni, your name's on the record on Haroni versus Randall, DBA Tilchin and Hall, PC 2501675R. Mr. Haroni, your name, sir?
Matthew Haroni.
Ms. Ford?
Maureen Ford on behalf of the defendant.
So that was not a very fruitful conversation. I think I had sat down for 70 seconds and was told you guys were already out.
Yeah.
Well, all right. So there's no opportunity, no chance of resolving this, correct?
No, it does not appear so.
All right. So what would you like me to address? Let's start with that. You want me to rule on your motion to strike the amended complaint and to seal the document pertaining to his communication with the attorney grievance?
Correct, Your Honor.
Mr. Haroni,
Yes.
do you acknowledge that you did not file, after reading their motion, your amended complaint appropriately?
Your Honor, I may have been confused, but I did file the amended complaint after I initially filed in small claims, and then when it was removed to general civil, it was within 14 days of that removal.
But you have to file within 14 days. That's not the 14 days. That was an order. That was, they're supposed to answer the complaint within 14 days. You want me to seal this record, identify the interest, counsel?
Yes, it's Exhibit 22 to the amended complaint. That is a document where Mr. Haroni had submitted a request for investigation against Defendant Randall with the Attorney Grievance Commission. That request for investigation was dismissed back in May of 2025. So attached as Exhibit 22 was Mr. Randall's response to that request for investigation. The attorney grievance process is a confidential process for reasons that the judge is probably well aware of. And so we just ask that that document that was produced in that process be sealed from public.
All right, and you received this, correct me if I'm wrong, Mr. Haroni. Did you receive this when the Grievance Commission told you they were not going to take any action against Mr. Randall?
Yes, sir.
What is the relevance of that to any claim or count that you have?
Your Honor, the statements that he made in his admissions to the AGC are full of untruths and speak specifically to my family and my children.
Okay, but what? Okay. Ms. Ford, let me ask you a question. Again, I hate to keep apologizing, but I am going to apologize if I haven't already. I've read this, but geez, oh, Pete, my secretary tells me there's 400 pages here. So I did not go through this thoroughly, but do you agree that if any of these claims survive, that he could at least use the statements made to the Attorney Grievance Commission by the defendant as impeachment evidence?
No, I don't believe so. And all of the statements made in that document are taken from other documents that are already in play. I mean, that's just a recitation of the facts that occurred. So those facts are alleged in other documents. I don't think it's necessary to use what was in play with the Attorney Grievance Commission at all in this lawsuit.
Well, look, let me just see this for a second. let me look at this for 1 minute. Give me a second.
Sure.
Is there anything in here, sir, that you would need that you can't prove otherwise?
I could write an affidavit regarding the contents of the AGC response, but I redacted the confidential information, and those responses only contain information about this case and these facts.
All right. All right, I'm gonna strike the amended answer to the amended complaint. If you want to file an amended complaint, you have to seek leave of the court. So I agree with the defense. The amended complaint is stricken from the record. In the meantime, since I'm striking that, I'm also, as of this time, ordering a sealing of the Exhibit 22, which is the response of the defendant to the Attorney Grievance Commission. That's the one you're referring to, correct, counsel?
Correct.
So the motion to strike amended complaint is granted. You're going to have to seek leave of the court. In the meantime, I am sealing Exhibit 22 as referenced in the documentation here. And if you think that that is going to be something that you need to focus on, then you can after you seek leave and acquire leave of the court, you can ask me to unseal that. But I can't imagine me changing my mind, but I will keep an open mind on that. If you're going to seek leave, you better do it quickly.
Okay.
Now, this seems so personal to me between what is going on here. It just seems very, very, very personal. I'm just going to tell you right now, that debt that they were attempting to collect was not against you. She's right. You're not the real party in interest. I don't know how you're going to get this to libel or slander or any kind of defamation based on anything that I read. But again, I'm telling you both, I have not read this in detail like I will before the next time. So you pursue this as you wish, but you have to have a valid claim, Mr. Haroni. Okay? Otherwise, you're subject to sanctions. That's all I'm going to say at this point. Prepare your order, Ms. Ford, send it over, and we'll go from there. Anything else? Any clarification that's needed, Mr. Haroni?
Not at this time.
So you're not to distribute that document. You understand that. I'm ordering that sealed. You understand that?
Yes, Your Honor, I understand.
Okay. Ms. Ford, anything else?
Just for clarification, so in regards to the motion for summary disposition, are you denying it? Are you holding it in abeyance?
I'm not going to even rule on it. I'm going to give him an opportunity to amend his complaint in fairness.
Okay, and then go from there? Okay.
Correct.
All right, understood.
Thank you very much. Have a good day.
Thank you. Have a good day.
Bye now.
Bye-bye.
Jennifer, you heard what I just said. I'm granting, will you write all this down? I mean, I got documents.
Yes, Judge, I made notes that you are
Jeez.
restricting the amended complaint and sealing Exhibit 22.
Correct. And telling him he can seek leave. Well, a lot of trees were killed on this case, huh?
Yeah, 460 pages, Judge.
Is that what it is? I thought I was overestimating when I said initially 250 or 3, I think I said, and then.
Yeah, no, you were underestimating, believe it or not.
All right. What do I have to send down? I'm going to keep the rest of this. These are all my copies. I'm sending.
You had a set, and there was a packet that I have that's bound.
Okay, thanks. All right, let me just get organized here. And then I'm going to call Michigan Legislature here momentarily. Look at this. All right. Michigan Legacy Credit Union versus Kathleen M. Kine, 19W2692GC. All right, Mr. Mull, your appearance again?
Oh, I'm sorry, Your Honor. This is Andrew Gallstra on behalf of Michigan Legacy.
No, this is another Michigan Legacy case I got.
Understood.
Your appearance?
Good morning, Your Honor. Ed Mull, MAHL, P27115 for Michigan Legacy.
Ms. Kine, your name?
Kathleen Kine.
Any issues?
She did bring a lot of documents this morning. There's a couple of documents she did not bring. She made a list of those.
What are those documents you didn't bring?
Did you ask me what goes out?
Yeah.
W-2 forms for the last 3 years.
Income tax
2022,
return.
income tax return.
Wait a minute. You guys are talking to yourselves. Talk to me. I can't hear you.
2022 tax return.
She didn't bring W-2 forms for the last 3 years, you said?
We asked for W-2 forms for the last 3 years.
And she didn't bring those?
No.
Or the 22 tax returns?
Correct. Or a deed to the real property. And that's those 3 items.
What do you want me to do?
We'd like to put this over a couple weeks in the control date. I'm sure she'll provide those to us because she has provided other documents.
Jennifer, give me 3 weeks, please. So you have to send him those. If he's satisfied, he'll cancel the creditor's exam. But don't just not show up if you send him and assume that he's satisfied. Okay, so your obligation is to be here on August the what, Jen?
The 12th? Is
That's-
that enough time? 2 weeks?
Another week.
Okay. The 26th?
26th at 8:30, okay? So make sure you get him those, ma'am, all right?
All right.
Do you have any questions or you?
Can we do that by Zoom?
Yeah, I could care less. I was surprised you showed up. You guys can appear by Zoom, but you have to obviously get them the documents ahead of time, okay?
Thank you, Your Honor.
Thank you very much.
I have 2 Zoom matters before you this morning. Would you prefer that I stay here or that I go next door and check in?
You can do whatever you want. Let me see what I got. What cases do you have?
Good luck. I've got one which is called,
Just come up and tell my recorder. I'm gonna move on here. Samsung, what do you have there? What's your name?
Right.
He's one of your 930s, Judge. He just logged back in. We're good.
What's his name?
That is Mr. McCrae, John McCrae, City of Westland case.
Okay, LVNV versus Josie Dominic, 2403963. I'm gonna get,
that's mine, Judge.
okay, your appearance?
Good morning, Edward Mull, MAHL, P27115 for LB&B funding.
Is Josie Dominic here?
I have not had her check in, Your Honor.
Let me see. Well, it was scheduled for 9:30. You filed, actually, she filed a motion to set aside the default, right?
Well, we filed a motion to set aside the default because it was dismissed for failure to file.
Oh, I see. Yeah.
It was served, I think, 4 days before the dismissal date, it just didn't reach you in time. So, it was served by all.
All right.
So what we're asking is that the case be reinstated. The defendant did not file or answer.
I know, but here's how I do it. Case ordered reinstated. Plaintiff to serve defendant by first class mail at her last known address. At her last known address. A copy of the summons and complaint and the order granting reinstatement. Defendant shall have 28 days to file an answer to complaint and affirmative defenses.
All right, so we're going to give you an order of reinstatement, and then we're going to serve the defendant with a copy of that order of reinstatement and also
A copy of the summons and complaint to her first known address, and then you'll file a proof of service saying you did so, and if she doesn't answer in 28 days, you can submit your default. Okay, so that's that on that one, and for the record, it's 9:56, and this was scheduled for 9:30. What other one do you have? What time's that at?
That was it. I think that was set at 9 o'clock. It's Elsa Holly Medical Consultant versus Carmeet Davies.
It's at 10 o'clock, Your Honor.
Oh, it's 10 o'clock.
Okay, I'm sorry.
That's okay. City of Westland versus John McCray, 2500930.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good morning. I could not pull up this answer for some reason. I don't know why. I just couldn't get the answer of the defendant. Mr. McCray, your name?
McCray.
Only have silence.
Mr. McCray, your name?
John McCray.
Okay, so now I was able to pull it up for some reason this time. Well, what do you want to say, Mr. Cox? Did you read his answer? He's saying you guys didn't submit it.
Yeah, Judge, a couple things have been going on. This is about a $900 unpaid ambulance bill from 2023. The defendant's alleging my client didn't timely bill it. And over the course of the litigation, the time the court afforded us, he's contacted his insurance company. He's made a representation to me that they're going to pay $400, and that check was put in the mail end of June. I've been checking with my client about every 10 days, and they don't have any record of receiving $400. But I will note that the $400 is at less than half of the amount, and there's not an accompanying adjustment. So this seems to be a partial payment whereby the defendant would, in plaintiff's eyes, be responsible for the remainder. I don't know. I talked to Mr. McCray in the breakout room. Part of me is inclined to adjourn this about 30 days to see if we can get that money and negotiate on the balance. The court set the matter for trial on August the 26th. And so I don't want to run afoul of the court's order and dates, which is why we put this motion on the board to begin with. But right now there's a partial payment somewhere. We haven't tracked it down, but then there's a little bit of work to do on negotiating toward the remainder and seeing if we can resolve it. So, alternatively, Judge, the defendant did file a response to the motion, a letter or a couple sentences that basically said that very thing, that he's contacted insurance and they're making partial payment. But so I think the court's options are adjourn it or grant the motion and then wait for the money and try to collect the remainder. But we are agreeable to an adjournment. I don't know if we can use the trial date as a motion date and reschedule the trial, but that might be one pathway.
Did you submit it to your insurance carrier, Mr. McCray?
I recently contacted them as soon as all this started because I thought I got paid by them. And fortunately, I got a sympathetic ear, and that's what got me this far. I'm not quite sure where they came up with the number $400, but like I told them, I appreciate any help they could give me.
I know, but I don't know.
I did submit, and I had to fax over to my health the EMS bill that I recently received in our first date with our first date here. I did have to submit that. They needed the detailed bill before they could do anything.
I hate to tell you this, it's your responsibility to contact your insurance carrier. When you got the bill, you should have submitted to your insurance carrier. I don't know why you're blaming them.
Well, I'm not really blaming anybody.
You're the one responsible for the bill, and I know those are outrageous bills for sure. I mean, EMS services, when somebody comes, picks you up, people have a tendency to think their taxes should cover it, and I can't say I necessarily disagree with them, but that's not my call. it's not covered by your taxes, and they submitted that to you, and you had the responsibility to go ahead and submit that to your insurance carrier. It's not fair for me to say, well, you wanted them to do it, they didn't do it, therefore they eat the money. And I don't even know if that's usually covered by insurance, to be candid with you, sir. So I'm sorry. What I'm going to do is I'm going to grant their motion for summary disposition. There's no genuine issue as to any material fact here. I'm going to give them $859 plus their filing and service fee. If the insurance company pays $400, you can deduct that from the balance. Give me your breakdown, Mr. McCray. I'm sorry, Mr. Cox.
Judge, we attached a proposed order, but we can obviously e-file that again. What we show on this is.
Wait a minute, let me check.
Oh, is this, I'm sorry, is it 33rd District Court e-filing? Yeah. We submitted it, well, I think we did.
Judge, I may have it in the pending box because the orders don't go down.
We can also resubmit it, but I will represent to the court that the principal amount is $859. We've got court costs of $104.35, which represents a $45 filing fee, a $38 service fee, a $20 motion fee, and a $1.35 e-filing fee, and a $75 statutory attorney fee for a total of $1,038.35. And that's the amount we've set forth in our proposed order, and I can e-file that if some courts like that we sent the order over a second time after the motion's heard. But I think we submitted it.
Judge, I have it. I
Okay.
can send it to your signature box.
And we would request the court check the box if the judgment order resolves the last pending claim and closes the case. There's two boxes there. We didn't check either one, it looks to me like.
All right. So if the insurance company pays $400, that's obviously going to reduce your liability here, sir. That's all I can say. So I'm going to grant the motion. I'll look for you to send me over the order, Jennifer, or if it's not already in my inbox. And I sympathize with you, sir. There's nothing I can do. Good luck to you. Thank you.
Mr. McCray, I would still encourage you to follow up with me with regards to where your insurance company sent that check so we can track it down and give you proper credit. And then ultimately also, if you want to make an offer on what's left, they don't have to accept it, but they might if it's a lump sum. So I'd encourage you to do that as well. Okay. Thank you. Thank you, Judge.
All right, thank you. Capital One versus Sims. This by Licity Sims, by Licity Sims, 2501326.
Judge, that's Mr. Bartas. He's in a breakout room with one of his 10 o'clocks.
Michigan Legacy versus Tyler Ryan Hurd and Michael Wayne Howling, 2501458.
Good morning, Your Honor. This is Andrew Gallster, P52839, on behalf of Michigan Legacy Credit Union.
Yeah, I read this. Give me 1 second here. All right. Is Tyler Hurd here? As I understand it,
had him check in.
As I understand it, you had service. You have service against Hurd. You do not have service against Howling, correct?
Correct, Your Honor. We're still attempting to serve defendant Howling.
Right. So this is just against Hurd, true?
Correct, Your Honor.
All right. And the balance owing, you told me, was $12,918.64 in your brief. What other costs do you have?
So we have court costs of $244, which includes filing fee, a motion fee, and service fees. $20 statutory attorney fee.
$20? You mean 75?
Or 75, excuse me.
That's okay.
And the total judgment amount is $13,100. Well, I have $182.64, but we're short $55 then.
Because you didn't add that in.
Correct.
13,182.64, you said?
Correct.
So it should be 337.64, right? Is that right?
Correct. Or 237, 13,200.
237.64.
Yeah.
Cool. All right, so submit your judgment. I'm gonna go ahead and grant your motion for summary. He didn't file a response. He didn't show up. Motion for summary disposition granted. You make sure that when you submit your order, if you would please, that you just indicate that the case against Howling is still pending.
Okay. Your Honor, we did submit the proposed order and judgment with the motion. Or would you like us to resubmit it?
You have it, Jennifer? Oh, wait a minute. Here it is.
Oh. I'm sorry, Your Honor, and I
don't. I'm going to need you to submit one, okay?
Okay. Thank you very much, Your Honor.
And make sure you include that about the case still pending against Howling. Thanks.
Okay, understood. Thank you.
Capital One versus Bosquetti, 2501643.
Good morning again, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
Morning. Mr. Bosquetti, how are you? Your name, sir?
David Bosquet.
Good morning. I'm sorry I mispronounced your name. Give me 1 second here. I want to pull up. Your motion. Okay, so I didn't understand that. It was something to the effect, misunderstood rules or something like that. And then we were scammed by Publishers Clearinghouse. Is that what you said, sir?
Yes.
How are you scammed by Publishers Clearinghouse?
Said that you had won a prize.
We won a prize.
I know, but how does that relieve you from this debt? What does that have to do with anything here? Why didn't you answer the complaint? And do you have a defense to this?
Am I allowed to help?
Who are you?
A friend from church.
No, I'm sorry, ma'am. I wish I could let you help.
That's okay.
But I just can't. You're not a lawyer, and I cannot allow somebody who's not a lawyer to practice law. Sir, is this your debt here?
No.
What do you mean, no? You didn't take out a credit card with Capital One?
You have a credit card with that.
Wait a second. Let's slow down here, folks. Now, ma'am, are you Mr. Busquets' wife?
I am.
Okay, but you're not a party here. Okay? They didn't sue you. So I can't allow you to help him, talk to him, represent him. I'm going to make sure he understands everything here. All right? They think you owe them $10,180.58. Now you're in a courtroom. You can't tell me, no, that isn't my card unless that isn't your card. You can't talk. Wait a minute. Your friend can't help you. Your wife can't help you. I mean, no disrespect, sir. I'm going to make sure that you understand everything, but you cannot confer with other people here. If they were in the courtroom, I wouldn't allow them near you by the podium here. We're doing this because we're trying to be nice, and we want people to be, I guess, We want people to have more convenient access to the courts. I want you to listen to my question. I want you to not talk to your wife or your friend and answer this question. Did you take out a credit card with Capital One? Yes or no?
No, I did not.
You never used the Capital One credit card?
No, sir.
It's got your name all over these documents here. You don't have to sign a application if you get the credit card and you start to use it and you don't pay on it. Then you're on the hook for the money. Do you understand what I'm saying?
Yes, sir.
Give me 1 second. I don't know what the Publishers Clearinghouse. Look, you didn't answer the complaint on time, and you don't seem to have a defense. You're writing the court administrator, I see here, and you're saying, I don't know what the charges are for. I did buy, you said 3 pairs of pajamas or something like that. What'd you say here? Give me 1 second. It would have been helpful if items purchased were listed, including the date of purchase. That may help to determine if there were any fraudulent purchases. I do recall buying pajamas, 3 pairs of Dockers slacks, 2 pair of denim pants, and a light jacket. My wife and I are 83, have been scammed by Publishers Clearinghouse. We struggle to pay the debt this caused with our Social Security, with our SSA and pensions. Did you make a police report? Who scammed you? You can't just say Publishers Clearinghouse. Who scammed you, sir? Sir, are you listening? Listen to me. Who scammed you? And how did they scam you?
Publishers Clearinghouse.
I know, what'd they do? Talk to me, sir. You got to talk to me. Don't talk to your wife. Sir, you have to talk to me. Please talk to me.
I didn't have to have the money at the time, and I was a little bit late, but I did pay for it.
Pay for what?
Those pajamas, I guess.
How did Publishers Clearinghouse scam you? Did you make a police report? Sir, you got to talk to me, please. I got all these people waiting. I can be patient, but I don't want to keep them waiting. Would you please talk to me and tell me how Publishers Clearinghouse scammed you, and did you make a police report? Man, sir, are you capable of driving? Do you drive a car?
Yes, sir.
Do you have a valid license?
Yes, sir.
Why don't you drive up to the courthouse? You live right half a mile, 3/4 of a mile from here. Do you mind doing that? Will you do that for me, or is that going to trouble you some way? Mr. Bosquet, you got to talk to me, sir. We got to talk. I feel like you got to help me out here. Can you drive up to the courthouse?
Yes, I did.
No, can you now drive up to the courthouse? You can't be more than 4 minutes away. You live on Jackson and Trenton still, right?
Yes, I did drive in.
Who is the woman, the friend here? Listen to me. Tell me your name.
Holly Tiss.
Spell your last name.
It's Thisse. They are at my house right now. They're not at their house. They don't have internet.
Where's their house?
Their house is in Trenton.
Where's your house?
In Woodhaven.
How far are you from the courthouse?
Probably 6 minutes if I don't hit the train.
Are you just friends with them? Or are you related to one of them or not?
My husband is related to them.
How?
David's wife, Sally, and my husband's grandfather are cousins.
Okay. I need him to talk to me. He's not talking to me.
He has dementia.
Yeah. See, that's what I was worried about.
Yes.
That's why, okay, I got it.
We can drive over.
Does Mrs. Bus?
Yeah.
It looks like he owes this debt. I'm just trying to figure out if somebody scammed him, and if they did, I want him prosecuted.
I'm beginning to think that the issue was the dementia and not the scam with this particular debt.
Yeah. All right. Why don't you drive him up here? Can you do that? You got a valid license?
Yes. Yep. Right now.
Just be careful, okay, Miss Palmer?
Okay.
You can do what you're going to do and then come back in 20 minutes or so, or half an hour.
Do you
Okay.
want me to come up there, Your Honor?
You don't have to come up here. I'm just saying you could Zoom.
Okay.
No, but I'm just trying to say you don't have to wait and listen to me go on with everything else. You can come back at 1:45. Okay?
Okay.
Thanks.
Okay.
Thanks. Come on up, folks. We'll try to handle this. I'll figure it out.
Okay.
Albert Allen Wellens, 248-37204.
Good morning.
Your name?
Albert Allen Wellens.
You have the money here?
Last time I was here, I made a payment arrangement. As soon as I made that arrangement, I lost my job. I'm back working.
Slow down a second. Did you make a payment arrangement with me?
Yes.
$40 a week starting February 14th.
I did, and I lost my job.
What did I tell you if you didn't have the money?
I don't remember.
You remember. You remember, because I tell everyone.
What did you say?
I told you if you didn't have the money to call the court, we'll go on Zoom or come up here on or before the due date. Did I say that or not?
You know what? You probably did.
I know I did, because I tell everybody that. I might miss one out of 150. So you didn't pay a nickel since, hang on a second. You didn't pay anything since February 3rd.
Okay.
We show caused you. You didn't show up June 26th.
I didn't.
You didn't what? You're not going to tell me you didn't get the mail.
Probably did.
You probably didn't? I didn't hear you.
I probably didn't get it.
You probably didn't get it? You assume you're not going to get it?
I never check the mail. My wife does, so I probably didn't get it. I probably didn't look. Honestly.
Where did you work at?
I was working at Manheim, but now I'm just doing roadie work.
Really?
Yeah.
For who?
It's an app with deliveries.
Listen, I'm going to help you here,
I know you do.
but you got to stop doing this, okay? We're easy to get along with.
You're a real Very good judge.
Well, gosh, thank you. You're the first one to say that since 2002. And that's when he was in front of me as a police officer. How much time do you need? Now listen, here's the deal. I'm going to let you make your own payment plan. What a great country. You could put in the robe on.
I could pay $30 every 2 weeks.
Okay. But what are you going to do if you don't have the money?
Oh, no, I can pay $30 every.
I know, but if you don't have the money, your car blows up, who knows? 30 bi-weekly beginning when? Tell me the start date.
What's the date today?
July 29th. So if I made it 2 weeks from today, that'd be August the 12th.
That's perfect.
Are you sure?
Sure.
I'll make it August the 15th. Now, if you don't have the money, what are you going to do?
Call.
You can come up here, honor before the due date at 8:30, or you can call and we'll go on Zoom. Okay?
Thanks.
Good luck. Just don't ignore me, please.
I
All
will not, sir.
right. Shanice Deanna Wright, 254B7050112 FY.
Sure, what Haynes, Shanice, right?
How you doing, Mr. Haynes?
I'm doing well, Judge. How are you?
All right, good, thanks. Ma'am, your name?
Shanice Deanna Wright.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
All right, so she's defendant 2. She has 1 count of UNP. How is she going to proceed?
We'd ask the court to read the charge.
Ma'am, I'm going to read your charge to you. It's contained in the complaint. It is alleged that you did, on or about December 28 of 23, utter and publish as true a certain false, forged, altered, or counterfeit instrument, deed, record, or other writing with the intent to injure or defraud, knowing the instrument was false, altered, forged, or counterfeit. It's more fully described as a check dated December the 19th of 23 in the amount of $329.59 drawn on Bank of America, naming you, Shanice Wright, as the payee, and the drawer or maker was Advisacare. That is a 14-year felony. Do you understand the charge and the possible penalty, uttering and publishing?
Yes, Your Honor.
You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to your lawyer not only today, but at all subsequent court proceedings. You have the right to a lawyer. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand everything I just said?
Yes.
You have the right to a probable cause conference within 14 days. Your lawyer, the new lawyer, will appoint you. If you can't afford one, will speak to the prosecutor. If you do that, if it doesn't resolve at that point, we're going to proceed to a preliminary examination. If the preliminary exam is to this 1 count, count 2, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
All right. So I'm going to give you August 12th at 9:30. That will be your PCC. You'll be in front of Judge Hessen, your probable cause conference. And your preliminary exam will be August 19th at 11. So August 12th at 9:30 in front of Judge Hessen. August 19th at 11 o'clock in the morning in front of Judge Hessen. Detective, I just want to ask a question before I have Mr. Haynes address bond. Was this presented to the Brownstown Liquor Store at 18427 Telegraph?
Yes, Your Honor.
All right. Counsel, what would you like to say?
Judge, this is an older case, but it would appear that Ms. Wright has not missed any court dates, so it's like the complaint wasn't issued until almost a year after the alleged offense date. She has a limited criminal history. I think I saw a couple of driver's license suspended on the record. We would ask the court to consider reversal or low on time as a result. She is employed. She's a private healthcare provider.
How much does she make there?
I think it's not.
How much do you make there, ma'am?
Our probably 15 hours, so my checks be about 300 every week.
300 a week? How much do they pay you per hour?
$20.
That's not bad. Maybe you could try to get some more hours out of them. She does, what does her criminal history show, Detective?
Your Honor, I don't believe that she has any prior felony convictions. The only thing that I show as of the time of this warrant application was completed was that she had 2 suspended license offenses. I believe that she has warrants for those, but aside from that, and dismissal on assaulting a police officer, I don't see any convictions.
You've had a warrant out of Southgate since 2021. You've had a warrant out of Dearborn since 2019. Why haven't you taken care of those, ma'am?
I was unaware of those. I actually just got pulled over in Dearborn and they said nothing about a warrant. So to my knowledge, that did not come up until I just got arrested. And then they told me I had a warrant in Southgate and Dearborn.
Where do you live?
Detroit, Michigan.
Where?
On Jerry Road in Southfield in Detroit.
Can you give me your address, please?
The address in the file is the correct one, Judge.
What's that?
The address in the file is the correct address.
On Van Buren Street
Yes.
in Detroit?
Yes.
She just got done telling me Joy Road to Southfield, I thought. Where do you live?
16572 Van Buren Street, Detroit, Michigan.
I thought you just told me you lived in Southfield.
No, I said Joy Road in Southfield, like the 2 side streets. There is Joy Road and right off Southfield, not in Southfield.
All right, what are you asking for there, Detective? And number one, did the department reach out to her at all after the warrant was issued?
Your Honor, we leave bond in the court's discretion, but yes, the department did make contact with her by phone to advise her of this investigation and scheduled a time for an interview. Ms. Wright, after scheduling that, failed to appear for that interview and did not respond to any contacts after that.
Did the department notify her of the warrant once it was issued?
Your Honor, this was Detective Ramsey's case. I can't say whether or not he did or did not notify
They
her.
notify you, ma'am?
No, sir. I didn't even know I had a warrant.
All right, so I want to be clear. You don't have to talk to the police, okay? But you have to show up in court. So I'm not going to hold it against you that they invited you to an interview and you didn't show up. But you make sure you show up. This is not going to be the end of the world. If you don't show up, you're going to make this a lot worse than you needed it to, and it's going to end up a lot worse. Do we understand one another?
Sir.
$7,500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with employees of the Brownstown Liquor Store. No contact with prosecution witnesses except through your lawyer. You're not to enter 18427 Telegraph Road in Brownstown. You cannot leave the state without consent. You can't violate a law, and you must appear in court as directed. Also, no contact at all. I'm going to try to pronounce this, Vijay Raval, Vijayraval. No contact with him. So don't go back to that store. And also, ma'am, you are not to, this was a Bank of America check, wasn't it? You're not to go to any Bank of America. Do you understand that?
Yes, sir.
You're not to go to any Bank of America branch. You understand that?
Yes, sir.
All right, now don't make this worse than it is. Show up, okay? Otherwise, I'm telling you, you're making a massive mistake. Good luck. We'll see you here on August the 12th, August the 12th at 9:30. Thank you very much.
Thank you.
Okay, I got them coming on this one. Did I call Liddy Sims yet? Jennifer?
You did, but Mr. Barta was in a breakout room. He's back now.
One versus Lucidia R. Sims, 2501326. All right, Mr. Barta, your appearance?
Good morning, Your Honor. Susanna Barta, P 65425 on behalf of the plaintiff.
I don't see her out there, is she?
I have not had her check in, Your Honor.
You can go ahead and take a default. It was scheduled for 9:30 and it is now 10:30. Go ahead.
Your Honor, it's damages in the amount of $3,846.37, plus court costs of a $75 filing fee and a $50.07 service fee. We would like to submit that default.
125. Your cost of 125.75, is that right?
125.07.
125.07. I'm sorry. So your total here should be 3971.44. Is that right?
Yes, there's always a question as to whether we're going to put the e-filing fee on there or not. And I don't, to be honest, I don't know. When we requested that, now that we have filing fees, and when we have a filing fee for $75, you guys charge us $2.25.
Oh, I get it. Well, I think you're entitled to those. I wouldn't deny that.
Yeah, I would. I just don't know if we actually include them in there or not. So
what do you want to do? It's a big decision. $2.25. You can't buy a Diet Coke today or something.
That's fine. That's fine. We will include that as well.
All right, 3971.44. You can submit your default. Do you have another one?
I do.
Which one?
I have Bank of America versus John Washington.
Bank of America versus John Washington. 2501095.
Good
He's
morning,
here.
Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
Good morning. Come on up here, sir, if you would, please.
Your Honor, I had a chance to speak to Mr. Washington before today's date. He also has reached out to our law firm through his debt consolidation firm. We've actually resolved it. He's actually made 3 payments with a 4th one upcoming. So we just need to get him a signed conditional dismissal for signature.
Your name, sir?
John Washington.
What do you want me to do? Adjourn it?
Yeah, and I would respectfully request maybe 45, 60 days, just because when you deal with a debt consolidation firm,
I know. I get it, but Lisa or Jennifer, listen, I don't care who you have represent you, but get them going, okay? You know what I'm saying? No, I'm not blaming you. I'm not blaming you at all, sir. I want to be clear about that. But he's saying, these debt consolidation companies, they typically move a lot slower than I would, okay? I'm going to give you till, let's set it the very first civil docket in September, Lisa, Jennifer.
September 2nd, which is the day after the holiday, or do you want to go to the 16th?
Let's give me the 9th. Can I do the 9th? Why can't I do the 9th?
You have probation. We can add it on the probation
9th
docket.
at 8:30, okay? September 9th at 8:30, all right? But yeah, get with Mr. Barta and hopefully you'll submit a conditional dismissal so you don't even have to show up on that day, okay?
Thank you.
Thank you. Any others?
Nope, that's it.
Have a good day. Thanks.
Thank you.
All right. ABC Auto Finance versus Brandon Michael Liley. 217B3702.
Good morning, Your Honor. Robert, plaintiff P6925.
You're cutting out badly.
Oh, sorry. Robert Zielinski on behalf of plaintiff P69250. Is that better?
Yeah, that's a lot better. Is Brandon Liley here?
I have not had him check in with me, Your Honor.
So he hadn't paid. You guys started garnishing wages. Now he wants $150 a month, right?
Right.
And you want at least $350 a month.
Well, I did when I filed that, Judge. I've been doing this 20 years. I've never seen a larger gap between what a defendant's requesting and what I've received. In just 1 month, I've received $1,900. And we had a garnishment.
Cutting out again. 19 what?
$1,900. We've gotten almost $2,000 in 1 month. after I filed that response. I mean, he's paid weekly. Like on the 25th, we got $529. 1 week on the 1st to $719, averaging about, the garnishment's averaging, bringing in about $475 a week. So, you know, I was looking to hopefully get some kind of agreement with him, but I put that $350 down before based on what he put in his motion, but based on forgetting, I'd have to say something like $800 minimum a month.
The garnishment's still in effect, right?
Yeah, it's still going. Yeah, like I said, I just got.
He did not file an objection to garnishment, right?
No, he just filed a motion for payment for the $150 a month. I served him with that, heard from him, but yeah, significantly more. More he stated, he earned more, significantly more than he earns states in his motion.
Well, what do you want me to do? I mean, I don't want to give you more than you requested in your pleading here, but then again, you still got an objection. I'm sorry, you still got a garnishment in effect. He didn't file an objection to garnishment. And honestly, I have to tell you, I don't feel real sorry for him. He hadn't made a payment since 2019. So if you want, I will simply deny his motion for installment payments and keep the garnishment in effect.
That's what I would ask for, Judge. Yeah.
Okay. That's what I'm going to do. Plaintiff, I'm going to just indicate defendant failed to appear on motion for installment payments. Garnishment in effect. Had not made a payment since 2019 until the last month or so, right?
Right.
Is that true?
That's true, yes.
I don't know where you are, but we're going to have a better connection next time, okay? Plaintiff's motion for installment payments denied. That was already set aside, right? I would have had to set that aside to issue the garnishment. I'm sorry, defendant's motion for installment payments denied. I had to have set aside the, Jennifer, would you check that?
Let's see, Judge, showing.
Counsel, you guys would have had to have filed a motion to set aside the installment payment order in order to issue a garnishment.
Well, I can tell you, Judge, this file had a prior attorney on it. I don't know that might have slipped through the cracks. I can look back.
Judge, there was an order entered January 14th of 2020 to set aside the payment order.
Say that again.
January 14th of 2020, there was an order to set aside the payment order entered.
Okay.
Okay. And then you started garnishing wages recently, and he started paying, right?
Right. Yep.
All right. Okay, so that's what I'm going to do. I'm simply going to deny his motion for installment payments, and you can put garnishment to remain in effect. You can indicate everything in there, okay?
Judge, I have an order prepared, and I'll send it to your box.
Well, I want to make sure this is a little bit different. I want him to make sure he submits this with all this in here, okay? Will you do that for me, Mr. Zielinski?
Yeah, you want me to submit the order denying it? And
yeah. I mean, I don't know what you have down there, Jen.
I have the scale form that the box is marked that the motion's denied.
Okay, then submit that, and I'll be happy to sign it. That's good. She's going to take care of it. Okay, thanks. Thank you. All right. That comes back. They can't. We're coming in. Granite Televalley versus Quillen, Roy and Melissa Quillen, 501-791. Is this going to trial?
No, Your Honor, defendant is not here.
Well, then go ahead. Come on up here. Your appearance?
Thank you, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
87 what?
87855.
What are they up to?
They gotta be close to 9, Your Honor.
I think they're over 9. Anyway, what do you want to do here?
We just asked for a default judgment. This is a termination of tenancy for just cause on a manufactured home, Your Honor. We've had several hearings. The original trial date was actually adjourned to accommodate some schedules. The court was very generous in that. But the defendant.
You know they're going to probably end up filing a motion telling me something, right?
They may, Your Honor, but I've got information from my client that he's actually moving out from the home.
Writ date you're going to ask for in 10 days?
10 days, Your Honor. He plans on being out by the August 4th. We'd also asked for costs of filing.
I'm going to give you a writ date of August the 8th. You didn't seek money damages, did you?
No, Your Honor, but just costs for the filing.
Who can do that? I can't give you that. Where are you coming up with this? How can I give you that? No disrespect.
It doesn't hurt to ask, Your Honor.
No disrespect, but I just can't do that. Writ date will be August the 8th. Thank you very much. Have a good day. Thank you. All right. Let me see here. What do I have? TD Bank versus Kristen Gazdecki. Mr. Mall, which one of the other one do you have? I got papers all over the place here. Which case?
It's hard to pronounce. It's Elza
Holly Medical.
Thank you.
It's a 21. It's probably in a file jacket, Your Honor.
Let me take this one real quick. TD Bank versus Kristen Gazdecki, 2502123.
Good morning, Your Honor. Jessica Kelly for plaintiff.
Good morning, Ms. Kelly. Where is Ms. Gazdecki? Your name, ma'am?
Kristen Gazdecki. I am on Zoom.
Good morning.
Good morning.
Did you two talk?
We
Yes,
did.
We had an opportunity in a breakout room. The parties have
Okay.
agreed it's not a matter of what is owed, but rather how it will be repaid. We talked about the options for that, but we do need a little time to work out the paperwork. So at this point, we're asking for a scheduling order.
Nah. You guys can do that in 2 weeks, right?
Ms. Gazdecki, do you think 2 weeks is reasonable?
Yes.
Adjourn 2 weeks, Jennifer. August what?
The 12th,
At
10 o'clock.
10 o'clock. So I'll ask you to get with her and hopefully submit an order today, right? Or tomorrow or the day after. If I say today, you'll do it within 2 weeks, right? Have a good day.
Thank you.
We'll see you. Thank you very much. All right, LVN is Jimmy Rose, 2502206. Is Jimmy Rose here?
No, Your Honor, I've not had the defendant check in.
Is, who's here?
Ryan Mullally, P88457, representing LVNV funding.
All right, you want to default?
Yes.
Go ahead and give me the figures and we'll default.
Damages in the amount of $1,499.24. Filing fee of $56.65. Service fee of $47.29. A statutory attorney fee of $75 for a total of $1,678.18.
Defendant failed to appear. Default judgment will enter. Relief requested will be granted. Judgment of default in favor of the plaintiff and against defendant 1678-18. You can submit your order for the record. This case was scheduled for 10. It is now 10:44. You should be all set. Thank you.
All right. Thanks, Your Honor.
Elza Holly Medical Consultants, MD versus Carmita Davis. 21W 728.
Good morning. Ed Mall, MNHL P27115 for the plaintiff. Your Honor, this is the defendant's motion to set aside a garnishment, but this case has been resolved by the garnishment and the satisfaction of the judgment has been filed with the court.
And Ms. Davis is not here?
Correct.
All right. So plaintiff's response, I'm sorry, defendant's objections to garnishment, just for the record, dismissed, denied. She failed to appear. And then you're saying the judgment's satisfied.
It's on the way to the court.
And then, satisfaction of judgment will be filed as judgment satisfied. True?
Correct.
Boy, that was a lot to have to wait for 12 seconds. Have a good day, Mr. Mullin. Nice to see you. Okay. Okay, let's take Capital One versus Biscuit, 2501643. If, there you go. Can you come up here, sir? I'm not quite sure how I'm going to handle this. I'm not sure he's understanding everything, Ms. Palmer. Sir, you can have a seat right there. How you doing, Mr. Biscuit?
I'm starting to wake up, sir.
Wake up? Yeah, I'd like to wake up. It's 10 to 11. But I've been up since 6, so that's okay. All right. Do you understand everything that's going on here?
Yes, sir.
Do you?
Yes.
Do you owe this debt?
Pardon me?
Okay, now listen, we're going to correspond. I'm going to keep my voice up nice and loud. Do you owe this debt to Capital One?
No, I don't. I never used their card.
But you didn't really deny it in this answer. You say, I might have bought 3 pair of Dockers, 2 pair of pants, light jacket, and pajamas. Counsel, do you have any of these bills?
So we have
bills from Capital One?
Yes, so we do have 12 months of statements, but it doesn't go back to the transactions he was making, but it does show the payments being made. So during that 12-month period.
Sheriff Povich, you have to take your head off, please. It's okay. So, all right, so it shows payments, but no transactions, purchase transactions.
No, we don't have back that far, no. Now, my understanding, and obviously, this information was elicited from the group when I was in the breakout room, but my understanding was the position about the published clearinghouse was that has put them in an insolvent situation where they do not have any money.
That's pretty clear reading this.
Yeah.
And as you know, you can't garnish or attach Social Security benefits.
Right. And I did indirectly, obviously I'm not their attorney, but I did indirectly talk to them about the methods of collecting on a judgment. And I mean, a judgment is only a judgment.
Can't commingle your Social Security benefits with other funds and have them protected. Okay? If you're collecting Social Security and that's the only thing you have, as long as you don't commingle them, if you have them put in a separate bank account, they can't get at those. Okay?
I retired from Ford after 39 years. And then I get that money from them, and then I get the security of
I don't know what you want me to do, though. What do you want me to do here, Ms. Palmer? I got a motion for summary disposition. I've got a gentleman telling me this isn't his debt. I was told by somebody else that he's got.
I was notified, sir, can I start?
Absolutely.
I was I was called by the people in New York had called me and they said that if I work with them, they'll give me this, and it was $100,000. And a few other things like.
You know what? I wish I was a circuit judge and those characters came in front of me. I'd give them every single day I could. Every single day I could.
That was,
just preying on elderly people. It just makes me want to stick the fat end of a ball bat down my throat.
This goes back to 2.5 years. I've worked in different areas and I had some things that I won.
Yeah, they
And
scammed
it
you.
was put up on a wall and the person that was.
Did you make a police report?
No, I did not.
Why not?
I thought that there was two.
Listen, I want you to listen to me in the back there. The wife of the relative of Mrs. Busquet. Do you have documentation to support any of this? Does he have documentation of any kind? I don't want you to answer by yelling here, but he needs to, if he has any documentation, I don't care how long it is, he needs to go to the police. Now, these are tough. You know, these guys are calling from Timbuktu. And they say that they're around the block. That just sickens me. I'm kind of at a loss, Ms. Palmer. I guess I'd like to see you get some statements. You're saying they're not available at all?
No, we just don't have them. So since this
Well,
is
let's get.
okay.
Listen, I want everybody to listen. Can you understand me, sir? I want to make sure you understand me.
Yes.
I'm going to have the lawyer send you itemized statements of the bills that were incurred through your Capital One card, and maybe it'll refresh your recollection. Maybe when you look at those, you're going to see, yes, I bought the pajamas and the slacks and some other things that I remember. And yes, these are probably my charges, or maybe they're not. I can't grant your motion to set aside default. I really need an affidavit showing, a signed sworn affidavit showing that you have a defense. And you can't do that by just saying, I don't know if these are mine or not. I don't think they are. You got to be sure because you're signing under oath. Do you still have your pension coming in? Yes, right? Yes?
Yes.
So if you owe the debt, and I'm not saying you owe the debt, but if you owe the debt, maybe you can talk to Ms. Palmer about setting up an installment payment order that's agreeable to both of you. I don't know. I don't know what to tell you. I'm going to have her send those statements to you, and you look them over and talk to whoever you need to talk to, and maybe it will refresh your recollection. Sometimes I go out and charge things and I forgot about it, and then when I look at the statement, it refreshes my recollection. And then I'm going to adjourn this for 3 or 4 weeks, okay? He can hire a lawyer. That's probably the best, but then again, he's probably got no money to hire lawyers, or not enough money to hire lawyers. Jennifer, give me an adjournment I'm adjourning the motion to set aside default judgment. And you didn't really file a motion for summary on this. You just, so let's do it that way. But you need to have good cause for not answering the complaint and a meritorious, a meritorious defense that's set forth in an affidavit, which is a sworn statement. Okay? In front of, you have to sign in front of a notary. You could use somebody here. You could use them at a bank. Every bank has notaries. Let's adjourn it 4 weeks, Jennifer. Give me August, she's not out there. When is my civil date? How about August 26th? August 26th at 9 o'clock in the morning will be the motion to set aside default judgment. Okay? Are you understanding me? I'll try to explain it better if you don't. Do you understand me?
Yes, sir.
You sure?
Yes.
Okay. And I think you understand me, right? Okay.
Yes, sir.
All right. I wish you well. So,
Your Honor, may I interject? So I'm going to be at a conference on the 26th. I'm standing in, but I don't know if you want me to be present since I'm
I could care less. You've
not.
been here. Why don't we make it a week later? Jennifer, what do I have? September 2nd as a civil day, right?
It is, yes, Your Honor.
At 9 o'clock in the morning, September 2nd.
Oh, no. I'm sorry, Your Honor. I apologize. It's not. You have state. You switch back to state. It's September 8th you have.
Oh. And what time am I going to do it September 8th?
Whatever time you'd like.
9 o'clock in the morning. September 8th at 9 in the morning. Okay, sir?
And the defendant's going to come in person. You want me to
Yeah, will you come in person? Could somebody bring him again? And you send him those records as soon as you can. It'll probably refresh his recollection, okay?
Your Honor, do you have a preference on whether I come in person or not?
No, you can come by Zoom.
Okay.
It's a little harder sometimes with some, you know what I mean?
Yes. It's not a problem to come in person too, Your Honor.
I think it's just better for him to be here. All right, that's it. Thank you.
Okay, thank you, Your Honor.
Midland, who has a quick one? Does anybody have a quick one?
You're all set, sir.
Good luck, sir. Who's here for Lake Trust Credit Union?
Good morning, Your Honor. Andrew Gallster on behalf of Lake Trust Credit Union.
Lake Trust Credit Union versus Jasmine Serafovich, 2544696GC. Okay, so what are we doing on this one? Mr. Serafovich, your name?
Jasmine Serafovich, Your Honor.
Ms. Gallster, you're here.
Yes, Andrew Gallster, P52839 on behalf of Lake Trust Credit Union.
All right, so you want to proceed?
Yes, Your Honor. We did discuss possibly a consent judgment, but at this point, the payment terms would be too long, so we'd like to proceed with our motion for summary disposition.
All right. What do you mean the payment terms will be too long?
Too long for the client. The payment terms would be too many months long into the future to pay off the balance.
Remind me how much the balance is on this one.
The balance is, as of today, $17,911.
All right. Give me 1 second here, please. All right. Okay. Mr. Serafovich, you didn't file a response, right?
No, Your Honor, I did not. I'm not sure how all that is done, so this is all new to me, sir.
Do you have any defense to this claim at all, sir?
The only reason I was moving forward is because I think that sale was not commercially reasonable.
I'd probably agree with you, but the law's not going to allow me to agree with you. What do you mean? They've set a high interest rate or something?
It's not that. I mean, I purchased the vehicle for $25,000, and a year later they sold it for $4,600 at an auction, which I understand. But I was trying to sell the vehicle on my own for like 13 to 15,000. It was like in that range that they were being sold for at that time, and I just couldn't sell it, and I had to let it go.
How many miles did you have on that?
It was 100 and I'm gonna lie to you, 20, 30,000, I think. It was a box truck.
Okay. But they sold it where, Mr. Gallster?
They sold it at an auction.
So that's the problem. That's all the auction yielded. Look, it's not that I don't sympathize with you, sir. Maybe the best aspect is, how much is he proposing that he pay weekly or bi-weekly or monthly?
Mr. Serafovic, if you'd like to.
I was gonna, see if I can do like $200 a month, and then later on, once I pay off more bills, I can probably increase that. Because I got a lot of bills coming in, so I got 3 kids at home. So.
Okay, can I propose something to you two?
Yes, Your Honor.
If you agree on the amount owed, and I don't know how you can fight that, you guys can do a consent judgment. I'll swear you in right now, Mr. Serafovic. I'm going to ask you a lot of questions just a few questions about your income and expenses.
Okay.
He's going to ask you some questions, and I'll decide what the installment. We'll do a separate installment payment order. Is that fair, Mr. Gallster?
Yes, Your Honor.
So I'm going to have him read out the figures to begin with, Mr. Serafovic, okay?
Yes, Your Honor.
And then I'm going to find out whether or not you agree with those figures. And if you do, we'll reduce that. He'll reduce that to a consent judgment, assuming you will consent to it. You don't have to consent. If you want, I'll hear his motion. I don't see a defense. Okay? And then I can decide the installment payment order today, and we can be done with this. And you're not worrying about it a lot, right? That's my feeling on it. You want to do that?
Yes, Your Honor.
Why don't you give me your figures, Mr. Gallster?
Okay. Damages are $17,640. We have a filing fee of $164.80. Motion fee of $41.20. Service fees of $45. Today's motion for summary disposition fee of $20 for a total of $17,911.
Now, do you agree that you owe that amount, sir?
I did take out the loan, Your Honor, so yes.
All right. So does he have your permission to sign your name to a proposed consent judgment calling for you to pay his client that amount of money with the understanding that I'm then going to go ahead and swear you in, and I'm going to decide how often and how much you can afford to pay?
Yes, Your Honor.
So, Mr. Gallster, does that satisfy you so far?
Yes, Your Honor.
So you prepare that consent judgment, and then I'm going to ask you to prepare a separate order for installment payments. You just indicate there an oral motion for installment payments was filed. Mr. Serafovic, raise your right hand, sir. Do you solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God?
Yes, Your Honor.
Okay, why don't you tell me, sir, how much you make in your employment? Don't just be honest with me. I want to know how much you make. You get paid weekly or bi-weekly?
Weekly, Your Honor.
And where do you work?
I work at CMAC Transportation.
How much do you make per hour?
$26.50.
And how many hours do you typically work per week?
Around 40 hours.
All right. So right now you're making somewhere in the neighborhood of $1,050 per week. Is that accurate?
Yes, Your Honor.
Do you have any other employment?
No.
Are you married?
I am.
Is your wife employed?
She is.
And how much does she make?
She makes bi-weekly anywhere from $8 to $9.50.
Gross or net?
Oh, that's net.
After taxes?
Yes, Your Honor.
So she's still making probably, correct me if I'm wrong, I don't want to put words in your mouth. Well, $950, let's call it $900, $1,800. She's probably making closer to 40, 42. Is that fair or not fair?
So she makes around $16 an hour, I think.
Okay. All right, now, do you have a house payment? Do you own a house? Let's start with that.
No, I do not.
Do you rent?
I do. It's my parents' house.
Okay, so do you have to pay your parents?
Yeah, there's no mortgage on it anymore.
Okay, so how much do you pay to rent that house or to live in that home?
We just pay the mortgage off. I was paying it on their behalf. That was the deal between my parents and I.
And how much was that?
That was $980.
Who's going to pay the taxes going forward?
I pay the taxes on my side.
How much are the taxes?
I think it just went up a little bit.
And nothing goes down anymore, does it?
Right. I'm not sure, Your Honor. I think the previous one was like $1,800, $2,000 maybe for the summer tax, and $700, $800, $900 for the
All right, I'm going to round it off and say $3,000 a year. Is that fair?
Yes, sir.
All right, what other bills? Do you own a home? Do you own a car?
Yeah, I do have a car that's through Lake Trust Credit Union as well, and I still owe like around $4,000 on it. That's about $220 a month.
What other bills do you have? You have a cell phone bill?
Yeah, for sure. That's about $80 a month.
Okay. What about utilities? How much do you pay in utilities, or do your parents pay those?
No, I pay for all that. It's anywhere from $200 to $300 a month.
All right, I'm going to call it $250. What about car insurance for you and any kids that are old enough to drive? And your wife?
$570 for all the insurance, vehicle insurances.
$570 per month?
Yes, Your Honor.
Do you have homeowners insurance on that car house that you pay?
It's $180 a month.
Okay. And all right. So what other bills? I know you got gas, you got food.
Yeah, I do.
How much do you think you spend in food and gas?
I got 3 kids, so I probably they eat like a garbage disposal. So probably $200-300 a week, maybe.
And how old are your kids, by the way?
My middle one just turned 6 today. The oldest one, she is 9, and the youngest one is 3.
All right. Do you owe any other credit cards that you're trying to catch up on? Or
I do. I have about $25,000 worth in credit cards. I have my wife's vehicle. It's about $380 a month.
All right, hang on a second. Let's slow down. Mr. Galster, how much do you want him to pay?
Your Honor, if he could, here, let me, run the calculations here.
I know, but I don't want to talk about how many years it's going to take him. I get all that.
If we could $300 a month or better, we would accept it.
Well, Mr. Serafovich, you think you can only afford 2?
For right now, Your Honor, yes.
I'm going to order that the defendant pay $100 and I'm going to let you ask him any other questions, Mr. Galster. I don't want to short circuit this too much. He's clearly in debt. I'll let you try to change my mind. I'm going to say $1.25 on the 15th and the 1st of every month. That's what I'm going to say.
Okay, Your Honor. Yeah, the only other thing that I would mention is that Mr. Serafovich did mention that he also has 3 vehicles and a camper. There's a cargo van, his own personal vehicle, his wife's vehicle, and then a camper.
Maybe you need to cut back a little, sir, going forward, so you're not struggling the rest of your life. That's what I'm ordering. 125 the 15th and 125 the 1st of every month until paid in full. This order is subject to review on motion of either party on or after January 15 of 26. Okay?
Thank you, Your Honor.
I wish you well, Mr. Serafovich. Thanks, Mr. Galster. You don't have another one here, do you, counsel?
No, I don't, Your Honor. Just confirming $125 every 2 weeks on the 15th and the 30th of each month?
15th, and I said the 1st of every month.
First, okay.
So
Thank you very much, Your Honor.
$125 biweekly on the 15th and 1st of every month until paid in full.
Am I going to get some kind of a letter about this, I presume?
Yeah, we're going to start this until paid in full, beginning August the 15th. Okay? Beginning August the 15th. Okay?
Great.
Thank you, Mr. Serafovich. Good luck, Thanks, Mr. Galster. Thank you, gentlemen.
Thank you, Your Honor.
Thank you.
All right. Midland Credit versus Edwin Tostage, 2401986.
Yes, sir.
All right. Appearances, gentlemen.
Good morning, Your Honor. William Hill, P. 28608, appearing on behalf of Midland Credit.
Mr. Tostage, your name?
Edwin Tostage, sir.
All right. So you filed a response, Mr. Hill, and you're saying that you're paying another garnishment, your wages being garnished on some other case?
That is correct, Your Honor.
How much? And are they truly being garnished? Is it truly a garnishment of your wages?
Yes, Your Honor. They were taking 25% of my wages until the garnishment for Midland Credit Management, and then they took 25%.
What do you mean they took 25%? You mean what's the name of the other company that's garnishing your wages?
Portfolio Recovery Associates.
How much do you owe on that one?
$7,000, Your Honor.
How much, counsel, is your client receiving in garnishments from Mr. Tostage right now?
The last garnishment was a huge one. Okay, it was a wage garnishment in the amount of $1,113.04. That came in on July 18th. I'm covering this for Midland, and I spoke with them this morning, and I was trying to get some authority to see if I could give him some room here to pay this off. Okay. Midland's position is that if the garnishment's in place, they want to leave it in place. I spoke with Mr. Tostage. He's made a reasonable pitch for installment payments. I don't have the authority to agree to that, but I would leave it to the court's discretion. If you want to entertain a motion for installment payments, I'm not going to pitch a fuss about it. Okay.
See how good that Mr. Tostage?
Yes, sir.
The old school lawyers. You got to love them.
Yes, sir.
How much did you pitch to Mr. Hill that you would pay?
$162 a month, Your Honor, on a remaining balance of $2,214.64.
That's
correct. That's
so
correct.
I'm not going to find that the objections are invalid because they're really not, or I'm not going to find that the objections. Is he right that he's going over the figure, the amount that could be garnished? I didn't do the math.
I didn't either. Okay, we're just showing that the last garnishment we received. Now, in addition to that garnishment, he did reach out to Midland and try to settle this up in lump sum payments. He made a $1,000 payment in February, okay, and toward a balance, and he's paid it down, and it remains at $2,214.64. We're all in agreement on that, okay. He's pitched $162 a month. Okay, I'm going to leave that to the court's discretion. Midland tells me they want to leave the garnishment in place.
I'm setting aside the garnishment. We're suspending the garnishment. We're going to enter an installment payment order that calls for the defendant to pay $162 per month, commencing on August the 15th. Can you do that, Mr. Tostage?
Yes, Your Honor, I can.
15th of every month thereafter until paid. Can you do all that?
Yes, Your Honor.
Perfect. Mr. Hill, thank you very much. You're going to prepare an order for me, sir?
I'll have Midland do that, Your Honor, and submit it.
I just want to make sure we stop the garnishment now.
Well, I think if you order today on the file, garnishment suspended, okay?
Yeah, I know, but I need an order so he can take it to his employer.
I see. I can rush it to Midland. I'm not an employee of Midland. I'm covering this because the attorney of record is ill, okay? So I'm standing in. So I'll have Midland send something to the court ASAP, probably by the end of the day.
All right, garnishment is suspended, deed to pay $162 per month beginning August 15th. Yeah, please have them do that. Then Mr. Tosted, you might want to call here first thing in the morning. 671-0201, extension 217. And the civil clerk will make sure you get a copy of that order. Jennifer, will you make a note to not let me forget about this, please?
Yes, Your Honor.
All right. Anything?
Thank you, Your Honor.
Mr. Hill, anything else?
No, sir. Thank you.
Mr. Toss, have a good day. You're welcome. Good luck to you, sir. Thanks. Nice having you here, Mr. Hill.
Thank you, Your Honor.
Infinity SPV versus Walter A. Perizon, 2404717.
Hi, good morning, Christine Miller, P81895, appearing on behalf of the plaintiff.
Good morning. And do I have Walter Perizon here?
Your Honor, I've not had him check in with me on Zoom.
Okay. Let me see. I got to remember this one. Did you guys not pray for a sum certain? Is that why you're filing a motion for entry of default judgment? Is that what happened?
I think it did. I took this case over. I don't know if it got rejected or whatnot. We got the default, so belt and suspended. I just filed a motion for entry of default judgment.
Why did I stop that, Jennifer? I wouldn't do that, would I? This has been
It doesn't look like on my file that they submitted a judgment, only the default. I'm not sure why.
Yeah, you guys filed, but they filed this, it looks like December 11 of 24. Why is it coming up now?
We got it. We served them. We had to file a motion for alternate service, so it took a while to serve them with a copy of the complaint. If scheduling or clerical issue on our side, we didn't calendar the deadline to answer. We got a notice of intent to dismiss for lack of progress.
Good enough. So you want a judgment for this amount, right? So let me just go over the figures with you, please.
Yes.
7604, attorney fees 75, 7679 is a total judgment, true?
Correct.
And there was no response filed, true, Jennifer?
Correct, Your Honor.
Motion for entry of default judgment granted. I'm going to grant that. I'll note that the case was scheduled for 10:30. Then it was given 15 minutes. It's 11:19. And I'm going to go ahead and grant the motion. And you can submit your default judgment. Okay?
Today. Thank you.
Have a good day. Thank you.
You as well. Thank you.
Boyd Adams versus Dylan Jones.
He was just going to use the restroom.
Oh, you want to use the restroom? I got plenty to do.
I'm fine.
I got plenty to do here.
No, I know you do, sir. Where's the podium here?
Do I have Dylan Jones here?
Pardon me?
Do I have Dylan Jones here, Jennifer?
No, Your Honor.
And there was proper service?
Yes. I've got a copy of the service from Mr. Suzy.
So June 11 of 24, he dated this. What? He's got to be careful on these. It must have been June 11 of 25 he served her, right?
Yes.
All right. Okay. Give me 1 second.
Here's a copy of it. Okay.
All right. How you doing there, Mr. Adams? All right?
Yeah, fine. Thank you.
Good. Well, it looks like you're going to be a winner today. She didn't show up, or Dylan Jones didn't show up, rather. So it's going to be a non-appearance default. Services were and you're only asking for $750, right?
I calculated out how much the time that he had.
Yeah, but you Claimed only $750.
Out of 1,100, it's fair.
Okay, $750, and then you also get your filing fee of $68. How much was your service fee?
$38. I think 38.
Let me just double check that. $38.75. Do you have any other out of pocket here?
Well, all my materials, but yeah, I was not trying to get something for nothing. I was just trying to recover what I gave him.
$857 will be your judgment, okay? I can't give you more than you prayed for in your complaint, but I will give you that. Defendant failed to appear. This was scheduled for 10:30. It's now 11:21. Default judgment's entered in favor of the plaintiff and against the defendant. You go down the hall and they'll give you a copy of the judgment.
Okay, thank you.
Have a good day. Good luck. Do we have Barkovich out for?
I don't see the county out there.
Judge, he's still in a breakout room.
Bankovich, I mean. Epic Property. Epic Property versus Kenneth Jordan Daniels, 2502850. Good morning, Mr. Ozinski. Your appearance?
Good morning, Your Honor. Donald Osinski on behalf of the plaintiff.
This is the time scheduled for a bench trial. Defendant's not here. There was service, right, Jen?
Yes, Judge. This is a landlord-tenant first hearing with second mailing.
Right.
Yep,
But did they pay for a second filing?
they did.
Yes, here it is. Okay, counsel, you can go ahead. I'll give you a default.
Thank you, Your Honor. With the non-appearance of the defendant, plaintiff would like to request a default judgment in the matter. I'm showing rent to retain as $844.81. Cost in the amount of $184.17 for a total redemptive amount today of $1,028.98. That amount to be paid or the defendant to return possession of the property on or before August 8th or writ to issue.
All right, and how much are your late fees?
Your Honor, this plaintiff has a $50 late fee.
Okay, good enough. So I'll go ahead and authorize that. You can submit your default judgment. 102-898, writ date will be August the 8th. Epic versus Ashley Leday, 2502853. Ma'am, your name?
Ashley Leday, sir.
Counsel, your appearance?
Good morning, Your Honor. Donald Osinski on behalf of the plaintiff.
Ma'am, did you listen to and understand the rights on the video?
Yes, Your Honor.
Wish to speak to a lawyer?
No, Your Honor.
Do you intend to apply for funding?
No, Your Honor.
Counsel, tell me the total balance. I don't want a breakdown right now.
Yes, Your Honor. I'm showing a total redemptive amount today of $2,109.44, and the late fees on this are $50 as well, Your Honor.
But they're included in that, right?
Yes, Your Honor.
Ma'am, do you agree that you owe that amount?
Yes, Your Honor.
Can you pay that?
Yes, I intended on paying some today, and then I can pay the rest on the 8th.
How much can you pay today?
Today I believe it's going to be 1,000.
All right, here's what I'm going to do. I'm going to give you a judgment after hearing, counsel. 210944. If defendant pays, can you pay well, the 8th, you should have it done then.
I'm sorry, it's the 7th. It would be that Thursday.
I'll tell you what, I'm going to give you a judgment after hearing with a writ date of August the 11th, okay?
Okay.
August the 11th on this one, counsel, okay?
Thank you,
And she's going to pay you with $1,000 today, right?
Yes.
Okay. Okay. Anything else, Mr. Osinski?
Your Honor, as long as that complete payment's made by the 11th and the defendant informs me or my office that the complete payment's been made, we'll go ahead and agree to set that aside as well.
So that if you pay it, they're going to just go ahead and set aside the judgment and dismiss it. Okay?
Okay, thank you, sir.
Good luck. Thanks. I want to make sure we have whoever the detective is on this Bankovich, if that's him. Epic Property versus Anthony Johnson and Caitlin Smith, 2502857. So is that Robinson? We're gonna need him. If that's Bankovich or Barkovich, we're gonna need Detective Robinson. He can appear by Zoom. All right. Is Anthony Johnson here?
No, Your Honor.
Is Caitlin Smith here?
No, Your Honor.
And they paid for a second mailing. You could go ahead and take a default. Give me your figures if you would, counsel.
Thank you, Your Honor. And good morning, Your Honor. Donald Osinski on behalf of the plaintiff. With the non-appearance of the defendants, plaintiff would like to request a default judgment in the matter. I'm showing rent to retain as $895, cost in the amount of $223.56 for a total redemptive amount today of $1,118.56. That amount to be paid or the defendant to return possession of the property on or before August 8th. And then that there are late fees included in that amount. They are below the $70 cap as well, Your Honor.
Defendant failed to appear. Both of them did. Default judgment letter in favor of the plaintiff and against defendants. Writ date will be the 8th of August, 11/18/56 is the amount to be paid to save it from the issuance of the writ. Do you have Peninsula Ridge? Yes, Peninsula Ridge versus Diaja Ruffin, 2502900. Is she here, Jen?
No, Your Honor.
I filed a dismissal on this one, Your Honor.
Case dismissed. Motion to the plaintiff.
Thank you, Your Honor.
Then I have Boardwalk Apartments versus Stan Young, 2502903. Stan Young here. Oh, come on up, sir. Good morning.
And good morning, Your Honor. Donald Osinski on behalf of the plaintiff. Your Honor, my next few cases do have late fees that did go over the cap that the court set. I have already reduced the late fees to coincide with the $70 cap as well, Your Honor.
All right, your name? Daniel. Did you listen to and understand the rights?
Yes.
On the video, I mean.
Yes.
You wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
All right, tell me the total amount owed after the reduction of the late fees to $70 per month.
Yes, Your Honor, and inclusive of court costs, I'm showing a total amount today of $858.68.
I'm sorry, 58 cents?
68 cents.
68. You have that money?
No, can I say something?
Sure.
My rent is always paid ahead of time. Like next month is paid now. And before that, what it do is this system that you pay on, it don't duplicate, it duplicates the same month. I can show you years of payments ahead of time, on time, before. Always.
You have your manager here? Counsel?
And we will see last month for the same thing.
It doesn't appear so, Your Honor. I am taking notes and I will follow up with my property manager today with regards to this issue because there was a payment made. Are your payments coming in at the end of the month?
So listen, wait 1 second. Why don't you call her?
Yes, Your Honor.
Or him. Call him up and have him log on here. I'll finish Park Place Apartments case. I'll go on to this criminal case and she should be on or he should be on by then. How's that?
Thank you, Your Honor. I will call them right now.
Have a seat. We're gonna get him on here. Park Place versus, go ahead, take your time and make that one call there, counsel. You can have a seat.
Park Place is his, Your Honor.
What's that?
Park Place is his cases as well, but neither defendant has appeared, so.
Right. So I'm gonna let him call on this one and get her over here. And you are Mr. Bankovich, correct, sir?
Yes, sir. Donald Bankovich.
All right, give me 1 second. I'm gonna call that case. Actually, I guess I could do it this way. Donald Allen Bankovich, 25G716663FY. All right, good morning. Oh.
Donald Bankovich, we were waiting for Marie to come here.
All right, Mr. Bankovich, your name?
Donald Bankovich, Donald Allen Bankovich, sir.
I'm going to advise you of your rights here, okay? You have the right to remain silent You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. At that probable cause conference, your lawyer will discuss this case with the prosecutor. If that's not resolved at that time, then you're going to go to a preliminary examination. You have the right to that within 7 days after the probable cause conference. And the people have to show that this crime was committed and that you were the one who probably committed the crime. They prove that, you'll be bound over for further proceedings. Do you understand that?
Yes, sir.
All right, so you'd go to the circuit court then. So I have August 12th at 9:30 as your probable cause conference. Preliminary exam will be August 19th at 11 o'clock in the morning. Do you understand that?
Yes.
Detective Robinson, your name?
Detective Gary Robinson, Gibraltar PD.
Has he been printed on this? He hasn't been printed on this one yet. How are we going to get him printed? Can you call down to the county and I'll prepare an order and I'm going to hope that they send it down to the county? Jennifer, try to enlighten Heather, will you please?
I will do so.
I mean, you might have a better opportunity to get the prints taken. All right, so I'm going to listen to whatever you have to say regarding bond.
Judge, I looked at Mr. Benkovich's prior criminal history. I saw an OWI from 2023, and he indicates that that matter is closed. There was nothing else as far as convictions that I saw. Apparently, he's got a charge in front of Judge Hessen. He's been in custody the last 10 days on that. Bond on that is $50,000, 10% plus a tether. Based on his limited criminal history, Your Honor, that's for a personal or rolling bond in this case. He's also indicated that he's going to retain his own attorney.
Does he have a means of income? What kind of income? What kind of income do you have, sir?
I have a full-time job.
Okay. Where do you work again?
Barton Mill.
Oh, so you make good money. How much do you make per hour?
Oh, about $35.
Detective Robinson, I'm sorry. Did you state your name yet? If you didn't, would you please?
I did. Detective Robinson, Gibraltar PD.
What was the, I'm getting so many of these. I don't remember what the other one was that I set the bond on.
The other one was a felony CCW violation. We took over 20 firearms from him.
Oh, yeah.
Carrying the 9.
Yeah.
Yep.
Okay.
I think you have him set up for 50,000, 10%, and then with a tracker by GPS. Yep.
Did you go in front of Judge Hessen on that case yet today, Mr. Benkovic?
I've been in front of Jennifer Coleman, sir.
Yeah, that's what I mean. You went in front of her today already?
Yes, sir, just a few hours ago.
Was the bond discussed, the 50,000, 10% that I sent?
Yes, with the tether.
I know, but did your defense lawyer address bond on that case today?
Yes.
Is the bond the same or did she lower it?
Bond's the same, sir.
What are you asking for, personal? What are you asking for, detective?
Sir, I'd like to see a cash bond, obviously. I have another case pending also with him that I hope to have through a prosecutor next week.
Jeez.
Yeah, and then previously we've already had, there were 2 or 3 trespassing cases at Gibraltar Boatyard and Humbug Marina properties. So
7,500, 10%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Jacob Simonkevich or prosecution witnesses. You cannot write him, phone him, see him, have anybody else do any of those things for you on your behalf, and except through your lawyer. No contact with prosecution witnesses. You have to get fingerprinted and photographed. You're not to go near, I want to be clear, no, you're not to go near 28731 North Gibraltar Road in Gibraltar. You understand all that?
Yes, sir.
All right, so August 12th, 9:30, August 19th at 11. Good luck to you, sir. Thanks, detective. Thank you. Thank you very much.
Thank you, Your Honor.
May I have a breakout with my lawyer, please?
He's not gonna be your lawyer anymore. We're gonna get you a felony court-appointed lawyer.
Oh, yes, sir. I need to, I'm confused. Is this all gonna be, is this 75 now? Is everything
You're
combined?
gonna have to post 750 on this case and 5,000 on the other case that I said.
750. Thank you, sir.
All right, good luck.
Thank you, sir.
All right, Park Place, are we ready on that versus Lays Taylor, 2502904? Mr. Osinski, your name?
Good morning, Your Honor. Donald Osinski on behalf of the plaintiff.
Is this a default? The defendant didn't show.
Yes,
Correct, on Taylor, on,
Lays Taylor.
yes, they did not appear on Zoom.
Or are you moving to dismiss? I don't know. That's what I'm asking.
No, Your Honor, we are moving for a default judgment.
All right, go ahead.
Thank you, Your Honor. With the non-appearance of the defendant, plaintiff would like to request a default judgment in the matter. I'm showing right to retain as $630, cost in the amount of $184.17 for a total redemptive amount today of $814.17. That amount to be paid or the defendant to return possession of the property on or before August 8th or writ to issue.
And the late fees are 50 or 70 or less, correct?
That is correct, Your Honor.
Default judgments entered in favor of plaintiff and against defendant. 814.12 is the amount to be paid, or 814.17 is the amount to be paid to save it from the issuance of the writ. The writ date will be August the 8th. Park Place versus Vincent Abercrombie, 2502905. Is this a default?
Yes, Your Honor.
You may proceed. Defendant didn't show.
Thank you, Your Honor. With the non-appearance of the defendant, plaintiff would like to request a default judgment in the matter. I'm showing right to retain as $1,720, cost in the amount of $184.17 for a total redemptive amount today of $1,904.17. That amount to be paid or the defendants to return possession of the property on or before August 8th, and I did cap all late fees at $70.
Defendant failed to appear. The writ date will be August the 8th. Default judgment entered in favor of plaintiff and against defendant, again with a writ date of August the 8th. 1904.17 is the amount to be paid to save it from the issuance of the writ. Did you get your manager here from Boardwalk?
Yes, Your Honor. Mr. Young actually just recently made a payment. It actually just cleared and there's a credit on his account for $95.45.
Boardwalk versus Stan Young, 2502903.
Good morning, Your Honor. Donald Osinski on behalf of the plaintiff.
Your name?
Stan Young.
Okay, so
I think what ended up happening, Your Honor, if I may, there seems to be a point where Mr. Young did make a payment near the end of the month for the current month. So he's been constantly behind 1 month at a time, but he gets caught up near the end of the month. So what I was going to suggest to Mr. Young is to discuss with the property manager in the office with regards to how we can go ahead and get him current sooner in the month so we don't have to, so we can just resolve this now.
How much are you saying the credit is?
It's $95.45.
When did you make your last payment?
So I made the last payment, I make a payment the 25th for the following month, which is for August. See, what happens is, from the system that we pay on, what it do is it don't show the correct month. What I tried to tell you guys last time I was here. What it do is duplicate the same month, but a different day. So.
Do you think you have more of a credit coming than $95.40? No. Shh. Just slow down. Do you think you have more of a credit than $95.45?
Yes, this month's paid for and
August
paid for.
Counsel, he sounds pretty convincing to me. He's either a really, really, really good liar or he sounds really convincing to me, and I'm pretty good at determining that. You're moving to dismiss this case, right?
Yes, Your Honor. Yes, Your Honor. I definitely want to dismiss this case.
I want you to tell them that the judge wants the manager to sit down with Mr. Young and go through all their books so this doesn't happen again. Okay, will you do that for me, please?
Yes, Your Honor.
What day did you make your last payment?
So
just tell me the day.
Okay, I made a payment the 25th for August.
I know, I get it. So they're suing him, and he's saying he made his payment on Friday.
So here, what it do is the machine that I pay under, I go pay and electronically send everything, a receipt. They give me a receipt manually, and they give me a receipt on my phone. So what it did is it duplicated the same month, but a different date. Like
Go talk to your manager.
The one that's on the 26th.
Tell her I want her to talk to him, or him talk to Mr. Young, whoever. What, I don't know who your manager is, but have them talk to Mr. Young. Maybe you can call over and sit down and say, I want to come and talk to you, but don't ever not procrastinate. You know, one thing that bugs me about these, Mr. Osinski, she should have told you, like, let's say Mr. Young did not show up today. I would have been giving you a judgment for that amount, and that's just not right. They have got to, I'm going to ask you to talk to all your clients and tell them when a payment is made, they got to email you the day before and tell you, so you're not going to come in and ask me for something that you're not entitled to, and they're not entitled to. Go ahead.
So last month, when I came here before, it got dismissed. The month before that. So like, I went and printed out all these papers of, it's probably like 4 or 5, maybe 7 years. This is for actually 3 years, to 23rd, 24th, and 25th. And I always did it like that from before they were the new owners or whatever, pay mine in advance. So I don't know why they keep.
He sounds convincing, Mr. Osinski.
Like,
he really does. Have your manager sit down with him sooner rather than later, okay?
Yes, Your Honor, I'm definitely making all notes. I think I've pinpointed a little bit of the issue. It's going back to the end of February with some DTE bills. So I'm making notes. I've looked at the ledger. I'm definitely going to request that our property manager reaches out. And then I did also make notes with regards to double checking amounts the day before trial instead of a couple days like they normally do.
Perfect. Thank you very much. Have a great day. Mr. Young, have a good day.
Thank you.
Good luck. You seem like a very nice man. Jennifer, are we done?
We are done until 1 o'clock, Judge, and I did just type up that payment order and send it over to you on that guy rather than waiting for counsel to get it to you.
Perfect. What do I have starting at 1?
Landlord-tenants, 1 and 130.
Oh.
And then you have a criminal sentencing at 2.
John looks tired. All right.
Come on, it wasn't that bad.
I didn't say I was tired, but I'm older than he is. You know, that's the way it works.
A little bit. A little bit.
All right, guys.
So I appreciate your patience. I have Tanya who's there, and I have Samsung SM. What's your name, ma'am?
Cassandra Strasser.
Okay, that's what I thought. Maybe we'll get some rhythm here once we get up and going. All right, this is file number 231359. This is titled Neighbors of Washburn Lake versus Cassandra Strasser. Mr. Nicholas Borden Sanford is here from the Paylitz Law Firm. He was here last time. Also, the manager, Tanya, is present. The other manager was Julie. Tanya, are you on this one?
Yes, Julie Gaylor is no longer with our company. So I'm the district manager filling in for her until we get another on-site manager.
Thank you. All right, we had a hearing on July 16th where we found that rent was $2,559.43 through July. Rent last paid April. Mr. Borden Sanford, what's the status here today?
Your Honor, we have not had been able to discuss a resolution, and we're still showing the amount due and owing, inclusive of court costs of $2,756.97.
Same as last time. Ms. Strasser, what's your position?
I have my money order receipts back from March saying that I'm up to date paid. I made a rather large payment end of February to get myself caught up. I wasn't able to use their online payment plan, so they told me I could send it to their P.O. box, send a money order. And I was never told that I could not continue sending money there. But I have been since March. And when I got this paperwork in the mail, I was unaware that any of this was happening.
So are you saying you've paid rent?
Yes, sir.
May? You paid April, May, June, July's rent?
Yes, sir, I have.
Paid it to where?
I have a P.O. box that they said that I can send it to in their package. It was Neighbors of Washburn Lake, P.O. Box, New York, New York. And I have an account number.
And how did you send the payment?
Through the mail. It wasn't allowing me to make payments online.
So you sent a certified check through the mail?
Yes, I sent a Western Union.
Tanya, I don't have your last name. What's your last name?
Stransky, STRANSKY.
And I've never met or spoken to Tanya. I did not know that Julie was not with the company anymore. That explains why I have not been getting responses via text messenger.
Well, when we were here 2 weeks ago, you indicated you tried to contact the manager. You have money orders back to March show that you paid the rent. So
yes,
it's the same thing you said last time. Your contention is you've paid the rent. Their contention is you have not. And you have the receipts for that?
Yes, well, I don't understand if they received April. I don't know why they didn't receive the month before, March. And they must have received my earlier of the larger payment to get caught back up in February. But yes, I have Western Union.
All right. Do you have the receipts there in front of you?
Yes, I do.
All right. Tell me, go through them starting in April.
Let's see. They're the, is there any way I can like flip my camera so you can look at them?
Well, just read them to me at this point.
Okay. I have a money order receipt, 2 of them totaling in $410 for the March. Same thing for April, May, June. And I've paid up, my July was sent also.
All right, and you have all those receipts in front of you?
Yes, I do, sir. Judge, I don't know.
All right. Okay, so I'm not sure what to do with this except continue it. We may have to have a hearing.
Your Honor, if I may, the last payment that was received from the community was through a lockbox as a Zigo transaction, and that was taken for on April 7th for $410. However, the balances continue to accrue due to the lot rent, the water sewer charge, late fee, and each month. So the payments of $410, and as the defendant has outlined, would not be enough to cover the ongoing monthly obligation.
I've never, I'm sorry to interrupt, but I've never put it.
Stop. I'll give you a chance to speak. Don't just blurt things out.
I'm sorry.
All right. Go ahead.
Yep, and Your Honor, as I was stating, that the payments have not been enough to cover the outstanding balance. It seems like she's been carrying, over $1,000 per month in a balance, and so she'll make a payment. However, that is not enough to cover the balance that is due and owing.
So are you telling me that you've received her payments of May, June, and July?
As reflected in the ledger I have in front of me, Your Honor, it seems that no payment has been received to the community since April 7th, 2025, and that was for $410 via a Zigo payment.
Zigo?
Yes.
That's a proprietary name?
Yes, that is. I believe that's a payment method that tenants can make at grocery stores, and as well as, I believe, getting a money order through that.
All right. So we have a fundamental issue of, I did get your brief, by the way, in support of non-payment of rent cases in mobile home communities, hopefully at some point. So we have a fundamental dispute here. She says she paid the rent. You say you didn't. Then you may be correct. Even if she did pay the rent, there may be some additional costs regarding late fees or utilities or other things. But the claim is that she's paid no rent since April 7th, and she says she's paid April, May, June, and July's rent. Previous manager is gone. Ms. Travitsky, is there a method that she described about sending payment to a post office box in New York? Does such a thing exist?
Were you talking to me? I'm sorry.
Yes, yes.
Yes, there is such thing as a lockbox that they can send money orders to. We actually try to discourage it just because it does take a little bit sometimes for us to reach them, but not anything like this many months by any means. We've not had any phone calls from her. Julie just stopped working for the company on Friday. So, you know, her notes were pretty caught up. We've not had any conversation with Cassandra at all, with her bringing in all of those receipts to prove that she has paid those so that we could look and try to find them. We've not heard from her at all.
Is there somebody in the office?
Yeah, me.
We
don't have an office on site at Washburn. We don't have an on-site office, so she would have to reach out to Julie through that number, and then Julie would either meet her at that location, or we do have a couple of offices. We've got one at Stanky that's 7 minutes away from Washburn that she could come down to.
All right.
I never know.
All right, go ahead, Ms. Strasser.
Okay, the previous that you were saying, that April payment through a Zebo, whatever the lawyer, I have never used any of those kind of payments. I have always used Western Union. When the park was sold not too long ago, I have a phone number and I have text messages in my phone that I thought I was communicating with Julie, and she just stopped texting me back one day, and I have never met Tanya. I had no idea there was a stinky resort that I could, you know, go give this stuff to. I did not know this information.
All right, well, you're all going to win a free trip to the courthouse in Centerville and sit down here in a trial and establish how much this is. Or you can try to meet with each other and see if you can come to some sort of an accounting. We can't do this by Zoom. Mr. Borden Sanford's never been to Centerville. This may be a free trip. You can have lunch at Yoder's, but we can't do this from here. So let me look. Because I've been on vacation, my calendar is quite crowded.
Looking forward to the trip, Your Honor.
All right, we can continue this to Friday, August 15th. At 11 a.m. live, not Zoom. If the parties are able to resolve it, they could submit a conditional order of dismissal.
I would love to do that. I would love to have your phone number, Tanya, so I could actually speak to you or meet you somewhere and get this resolved.
I'm okay with that. We can do that. That's not a problem. Let me give you can I give her my phone number now, Judge, or would you like me to wait?
Wait, I'm gonna put you all in a breakout room here in a moment after we take care of the other case. So everybody stay with me.
Okay.
Anyway, for now, this is continued for a live hearing. Ms. Strasser, meaning you need to bring any and all receipts that you have that you contend have been used to be paid. They will try to do a further accounting. Now, there may be some other issues. There may be late fees. You may contend I shouldn't have a late fee because I paid it. We'll see. So stick with me for a moment. We got behind schedule because of our technical difficulties. But let's talk about neighbors of Washburn Lake versus Melinda Weaver. I don't believe Melinda Weaver is here. We were here last time, and we made a finding that rent was $1,990 plus court costs gave us $2,187.54. Is that still accurate?
Your Honor, the defendant had made a payment since the last hearing, I believe, on or about July 24th, 2025. And so her rent to retain is actually $1,440.00.
1440?
Yes, and then
through
court
July.
costs. Yes, through July, Your Honor.
All right, the court costs we determined were $197.54.
Correct. So the total due and owing would be $1,637.54.
All right, I don't believe I have a judgment. It would be helpful if I did, but I don't think I do.
I could submit one after the hearing. That's more convenient.
Good morning. What's your name?
Melinda Weaver.
All right, Miss Weaver just came in. Why don't you come up here and have a seat? This was set for 9:45. She's way late.
I've been waiting. I was waiting in that other room since 20 after.
Oh, okay. Well, I wasn't aware of that. All right. Well, Melinda Weaver is here. Have a seat right there.
Right here?
Yes, thank you.
Okay.
All right. Mr. Borden Sanford says that you made a payment on July 25th, which has reduced the amount of rent you owe to $1,440.
Yeah.
Do you accept that?
Yeah.
All right. Court costs are $197.54. All right. That's why I wish I had a judgment. I could just hand it to her.
I apologize, Your Honor.
Well, you appear in a lot of jurisdictions and some judges do it differently. We like to have a judgment. I
have a money order here made out to him for $800.
All right.
And I have.
Now, just a minute. Tanya, how would you suggest they go about paying with a money order?
Well, the problem is we're pretty much everybody gets online and pays through those cash apps they can do a cash app, they can go to Walmart, they can pay them that way. When they mail them and they mail those money orders to a corporation, they have to almost mail them 15 days before they're due so that they hit the office for them to be able to be in our system before they hit late fees. They have to take into consideration with the mailing them all to New York. So we try to discourage people from ever doing money orders because of the getting lost in the mail and all those things. So we have put out lots of information on all the different ways they can pay.
Answer my question. Can she simply go to Stanky Resort and pay that to somebody?
She can bring it to me. That would be fine.
All right. Do you know where that is?
No. Where are you?
It's in Burr Oak. So it's 31500 Stanky Landing in Burr Oak, Michigan. We're literally 7 minutes away from Washburn, from that community. I just drove it yesterday. Wasn't even 7 minutes.
Okay, give me your number.
All right, I'll put you all in a breakout. So,
Okay.
All right, let's do the judgment. Through July, rent is $1,440. $197 in court costs, so the total through July is $1,637.54. Now, she's got $800 that she wants to pay to somebody.
I also have a blank check that I get paid on the 1st of
all right.
August.
Well, you're gonna have, of course, August 1st, another month's rent is due.
I know, that's why I want to
But,
go
all right.
and do it today if I can.
Very good. So you have 10 days from today, which would be August 8th. I've been studying this a little. Mobile home parks have changed.
I used to pay it, there's a wash house, used to be a wash house behind where my trailer is. And I used to go and stick my rent in there, and then whoever owned it would come and pick it up.
All right, well.
Me too.
The trailers, mobile home parks, were all mom and pop operations and locally owned, locally operated. 6% of people in the United States live in a mobile home community, which is 22 million people. And within the last 10 years, most of these parks are being bought up by large corporations. So
For tax write off.
I don't know. It's changing. And so it's gotten more expensive to live there, but the companies are making improvements that many didn't. So people like you that have lived there for a long time, used to handing a check to somebody, those days are
for
changing.
18 years.
All right, please don't interrupt me.
I'm sorry.
So the rules were different 18 years ago, and it was locally owned, and people are struggling all over the country, mostly struggling because the prices are going up substantially. So mobile home were sort of a last resort for a lot of people for low-income housing, but it's changing, and they're becoming modernized and professionalized and more expensive. So, Mr. Borden Sanford, I'd like you, if you would, to email me a judgment in this case. The address is on the pleadings. It's at 3B Civil at ST Joseph County MI .gov. 3B Civil at ST Joseph County mi.gov. It's right there on the notice. And if you email me that, I'll do it. Now I'm going to put all of you in a breakout room. Tanya, you can give her the information about where she can actually go to give somebody the check. Sounds like she's ready to pay her rent in full. And Cassandra and you can make arrangements to further discuss things. But I think that finishes your cases for this morning, Mr. Borden Sanford.
It does, Your Honor.
All right, I'm hopeful they can resolve that. You guys won't have to be here live, but I'll be here either way. So I'm gonna put you all in the breakout room.
Okay.
Okay, thank you.
Thank you.
Thank you.
And Miss Weaver, I can't put you in a breakout room because you're here with me.
Oh,
So, give her that address again, Tanya.
31500.
wait a minute. 1131
31.
500 Stanky Landing. It's STEINKE Landing.
NIE. Tiny Landing.
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 Yes.
And that's Burr Oak, Michigan.
Okay.
And I'm going to give you my phone number. Is that okay, Judge? So that you can just call me if you got the wrong address. That's 574-381-7668.
7668.
Correct.
Okay.
All right,
What's your name? Tanya?
Tanya.
Yes.
Okay.
All right, Miss Weaver, when I get that judgment, I'll get it to you, but it sounds like your intention is to pay the rent. And that will be good.
I've been in the hospital and I don't have anybody to take care of my money.
All right, well, it sounds like you want to deal with it, so you can go drop that check off over there and pay the other check and you should be good.
Okay.
All right, thank you. I'll send you that judgment when I get it. All right, the rest of you can go into the breakout room. Cassandra, hit the
Yes.
button that says join.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Sending that judgment over right now, Your Honor.
All right, Miss Weaver, you're good to go.
I'm good to go.
Yes, thank you.
I thank you very
All right,
much,
thank
sir.
you. All right, we're behind a bit. Mr. Bradshaw is with us. And you're good to go.
Okay, I'm gonna dismiss that.
Our next scheduled case is St. Joe River LDHA versus Diana Coy.
And I'd like to dismiss that case, Your Honor. Ms. Coy made that payment she just made that payment today.
Okay.
I'm confirming it today. She paid it yesterday. So I'll prepare a dismissal.
All right. Thank you. All right, that helps us catch up a little bit. That was 10:10. All right, next I have from you Three Rivers Limited Partnership Medallion Management versus Kelly Pedler, 251432FT. You submitted a conditional order of dismissal. We'll work out payments or vacate by August 11th. Is that correct?
That's correct. Sorry. The key provision is that she'll vacate by August 11th. She did state to me that she wanted to make payments and she wanted that included in the order, that just to show that she's making a good faith effort on that part of it. I told her when she vacated, she could contact the development and make some sort of arrangements to pay that past due amount. But the key provision is that she was going to be vacated by 8/11.
All right. You guys are fortunate enough to have missed out on all of our technical difficulties this morning. We had all kinds of problems, which have put us behind, but I think we're got some sort of rhythm now.
Okay.
So our next matter is Enchanted Glen. I think, does that finish you, Mr. Bradshaw?
It does. Thank you so much. Have a good day.
Thank you. You have one too. Hopefully. I'll get through this. All right, next up is Enchanted Glen versus Nicole Anzaldúa. Nicole Anzaldúa is here, and Greg Popovich is here on behalf of Enchanted Glen, and the manager is here. When we were here last, we determined that through July, rent was $875.14 plus $222.69 in costs, making the rent in July through July with costs $1,097.83. Mr. Popovich, what's the status here today?
Hello, Your Honor. Gary Popovich appearing on behalf of Enchanted Glen. We are here for the second hearing. I have rent. I'm not sure. I really appreciate Your Honor having notes and reflecting upon the first hearing. That means that's I appreciate that from a practice standpoint. We have rent though under her current ledger through July 11th. As I have notes reflecting it was $2,145.14, and that was what was emailed this morning by the manager to me. But we are on this. We do have a consistent reflection as to the court costs. The court costs were filing fee of $90, court's mailing fee of $13, service fees of $44.69, and a statutory attorney fee of $75. I also know that Ms. Anzaldúa, since the last hearing, has not made any payments and has not made and it has not reached out, to my knowledge, to legal counsel, which were some of the rights that were read to her at the first hearing.
Well, we're way off. I made a finding, or we took some evidence that rent was $732.14, and then we added $143 for $875.14. What you're giving me now is double what we had discussed at our last hearing. The rental rate is $143 per month. As of March 25 through March, rent was $283.14 plus late fees. So the defendant paid $490 on July 10th. We're gonna have to calculate this because, well, Ms. Anzaldúa, unmute your microphone if you would. Good morning.
Good morning.
You were here on July 11th. Was that your understanding that you owed $875.14 through July?
I had it written down. The last time I knew I was only supposed to pay like 1,000 and something.
Yes, that's right. So, Mr. Popovich, what is your contention rent is now?
As of today, from the property manager, it is $2,145.14, and that was the most current ledger through, and then it's July 11th, and the rent hasn't changed. So I'm looking back at some notes, Your Honor. I'm looking back at some emails from the earlier hearing just to see if I can help clarify. And then, if you don't mind, potentially the manager could provide some clarification given the figures and her better understanding of the ledger.
Yes. Could you state your name?
It's Kim Shaw. Well, I printed the ledger off this morning because I knew I was going to have needed to have an updated ledger. And on the ledger that I printed this morning, they've added the $940 to her ledger she has not done her recertification.
Oh.
She hasn't signed for her new lease, is where I'm assuming that's where the $940 is coming from. I just noticed it this morning, like I said, when I printed it off.
Okay, and Your Honor, I had not, so Ms. Shaw and I had communicated by email. I had not seen an actual ledger. She had emailed me the balance. So that amount is, we can get into that through testimony if we need to. And I do reflect, I have emails from 710 reflecting that the amount of rent due as of the time of the last hearing was 7/11. The amount of rent on the ledger was $1,122.14. That didn't include any of the attorney fees or statutory fees. And that would have included a full month of July's rent. And that would be, we're here now on the second to last day of July. So I think that that's the amount. And then Ms. Shaw, can you reflect, just provide me a little more clarification as to, because you're getting this ledger from corporate, obviously. So that's when you're referring to they are the corporate, and they've added, what is the $900 figure that you mentioned has been added?
The 940, from what I'm assuming, is because her certification was supposed to be done back in June, I think it was. Let me see. I think her ledger was due to be signed. Hold on. Might have been. I'm trying to see if I can find her file. I think her ledger was to be signed back in June. January, February, March, April, May or June. And because she hadn't recertified to renew her lease, I'm assuming that's where that 940 came from. She doesn't get the rental, that's not with her rental assistance. That's what she would be paying for rent.
Would it be safe to say that there's a market rate increase that she has now had retroactively applied by corporate because of her failure to have the recertification?
Yes.
So, but the ledger does reflect, and otherwise would have reflected, that through July, based on the earlier rent figures, she would have had a balance through July of $1,122.14, correct?
Correct.
Okay. All right.
Give me that number again.
$1,122.14.
Defendant contended that she paid $490 on July 10th. Is that reflected anywhere?
Yes, it's on her ledger.
All right, so let's go through this. The pleadings say that through March, defendant owed $283.14. Her rent is $143 per month.
$10 late fee for every month that it's late.
Yes, plus 20. So we'll get to that in a minute. So 283 times plus April, May, June, and July's rent. I really hate doing this in this manner, but we'll have to see if we can get 143 times 4 is 572 plus 283.14 is $855.14. Do that again. 143 times 4 is $572. So as of April 1st, she owed $283.14. So if we add in April, May, June, and July's rent, that's $572. We add that to $283.14, we get $855.14 plus 4 late fees, which is $80. Which is $855.14 plus 80 is $935.14. She paid $490 in July minus 490 is, oops. Should be 445.14. When the plaintiff contends It's 2,145.14. I'm not sure how.
For clarification, Your Honor, the $900 figure has been articulated, meaning that there is, since we were here at the last hearing, corporate has retroactively increased her market rent because of the recertification. So I'm running with that on the fly, and I need to look at the ledger to understand that a little bit better. But that would explain at least part of the difference from the figure I mentioned at the beginning of the hearing to the number you just calculated. I'm just as concerned right now, not concerned, but curious as to, I appreciate your math and running through that because that is consistent with the figures in the complaint that was prepared by our office. When we came on the 710, the communications were that there was a balance of $1,122.14, not including fees. So would it be okay, Your Honor, if I had a breakout room with my manager and she could email the ledger and her and I could.
Well, what she says, I assume this is where this came from. This is just some magic number. Oh, by the way, between our last hearing and now, corporate says you owe an additional $940. For what? So much per month, a $940 lump sum. They retroactively raised all the rent. No wonder she's confused. Legal aid's not here to plow the water.
I understand. I understand that confusion. That's why I want to talk with my manager so we can, it's not, the manager's getting the information from corporate. I understand. It's not a magic fix. I know what's happening. I've had some experience with this in the past. It's when somebody fails to recertify, corporate ends up in the review process, ends up upgrading the 143, let's call it in this case, to what's called market rent, and then it's retroactive. I understand that we're here on a second hearing, though, in our hands. There is some equitable view of this that's going to be taken by the court as to what amounts were disclosed to this young woman on the first hearing versus today with that amount. I'd like to, Ms. Shaw, if you could email me a copy of the full ledger, I'd like to dissect it, you and I in a private breakout room, and then, Your Honor, we'll be back. We'll come back in and we'll move forward at that time.
Ms. Anzaldúa, you stick with us. I'm going to go ahead and take up some other cases.
Okay.
And I'm going to assign Enchanted Glenda room 1 and Mr. Popovich to room 1. You should be able to join. All right, Mr. Anzaldúa, you just stay with me and we'll work on some other cases. So this one sort of went sideways on us. All right, next we have Sturgis Housing Commission versus Desiree Longs, or Denise Longs, and Denise Longs is here. Miss Longs, could you join us, please?
Yes, he put me on.
All right. Mr. Ryan Buckland is here on behalf of the park, and Miss Behringer, the apartment complex. Miss Behringer is here, and Miss Longs is here. I can't see her, but I can hear her. We were here last time, and we struggled through this one too. We found rent through July was $888. Court costs are $185.40 for a total of $1,073.40. And then there were some disputes about it. Mr. Buckland, what's the status here today?
Well, the good news is, Judge, my numbers match your numbers, but that's...
Oh, we're doing better than we did in the last case, so that's
right.
something.
So, but I think that's still where we're at as far as I know. I mean, I think Ms. Behringer tried to kind of explain last time. I think there was some confusion about the deposit not being paid, and there's still that amount is still owed.
Yes.
Is that true, Ms. Behringer?
Yes, and in reflection of her saying that she was paying $150 every single month at least, she was not. I do have her ledger report here, and we've got 150, 150, some months nothing. So no, she
was not truthful, saying that every month she did at least pay the 150. That was not true.
I made quite a payments of 150. More than once.
Sure, but there were still months that you did not pay. May 24, July 24, you didn't pay at all. February 25.
Yeah, that's when the problem
May
is.
25, June 25, you haven't made any payments, or July. So,
All right, Ms. Long, you indicated you were going to try to get some help from DHS or other agency.
Yes,
Have you had any success with that?
Well, DHS denied me, and I couldn't get an appointment with Action Agency as of today.
Well, I want you to continue to try to do that. This is another case where I wish I had a judgment so I could just execute it right now and give it to the defendant. But I find after we went through this the last time, through July, rent is $888 due. Court costs are $185.40. The total due through July is $107.340. On August 1st, another month's rent is going to be due of $332, $322.
Yes, I can make that Friday, and I also could, if I can get a payment plan to pay the
Well,
$100.
you can discuss this with them. That is due by August 8th.
322.
So I would, if I had a judgment, I would give it to you, and you could take it to Neighborhood Inc. and show them this is how much is due through July.
I went to them already.
All right. You said you couldn't get an appointment, or we're still trying to get an appointment?
With the Action Agency.
All right, then you could take it to them. Neighborhood Inc. didn't give you any help?
No.
Why not?
They said that because of my rent is subsidized. Well, that's what she told me.
Yes, they don't do subsidized housing because they've already get a benefit. All right, Mr. Buckman, can you email me a judgment in that amount? $888, $185.40. Date for the writ would be August 8th.
Yes, I'll do that, Judge. Do you want me to send it? Who all would you like tagged on that email?
Just 3B civil at stjosephcounty.gov. It's the address on the notice.
Okay.
Ms. Longs?
Yes.
My suggestion is that you go meet with Miss Behringer. And when you get this judgment, you take it to Community Action Agency. But you may not be eligible. Your rent is already subsidized. And the harsh reality is,
they just didn't have appointments. They just booked with appointments.
okay, keep trying to get an appointment. Hopefully they can give you some help, because otherwise, if you can't pay the rent, they could evict you on August 8th. Put all your stuff out in the street.
Okay.
And that's not good. So you want to go meet with your manager.
Okay.
All right. I would give you a copy of the judgment, but I don't have one. So we'll get one and I will send it to you immediately.
Okay.
All right. Do you have any questions?
No, thank you.
All right. You stay up with Community Action and you go sit down
Yes,
and
I
talk.
called them this morning. As of this morning, they still didn't have no appointments. She told me to call her every day.
All right. You keep doing that. All right. Thank you.
Thank you.
All right. Next we have Miss Behringer, Miss Buckland. You guys are good to go. I'll remove you. All right, we have. Oh, wait a minute. Mr. Buckland has another one. I kicked him out. Sorry about that. We'll do Centerville Mobile Home Park versus Harley Poling. Harley Poling is here. Ms. Poling, can you hear me?
Yes, I can.
And the manager.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
I'm a P33, so we're about the same vintage.
Well aged.
And the manager, Joshua.
He's under Kyle, asset manager, and also the property manager is here as well.
Well, we worked on this last time, and they sent me a brief again regarding lot rent only for mobile home parks. I got one from another law firm, and I've been on vacation, so I haven't had a chance to read them carefully. But there's a contention that you can't do this, but they're arguing that you can. But at any rate, we determined through July, rent was $2,224.44 plus court costs of $170.05 for a total of $2,394.49. What is the current status?
Your Honor, that amount is still correct.
Well, again, at least we matched. We were way off on the earlier case. They're still working on that. Miss Poling, what's your position?
I have $1,100 that I can pay today.
Well, that's a good start.
Oh.
All right.
I can pay.
Now,
hang on, I have 100 I could pay today.
how much?
700.
All right. Well, through July, you owe $2,224.44.
Right.
$170 in costs for a total of $2,394.49, and they'll certainly accept any and all payments. Partial
Well,
payment.
they have
partial
closed my. They haven't allowed me to pay any kind of payment. It was either the full payment or no payment at all.
I'm not sure about that.
That would have to be the case up until entry of judgment, yes.
Yes. All right. Now, they'll accept any payment and apply it towards your arrearage. But the only thing that will cure it is paying the entire amount. Now, on August 1st, your rent is due for August.
Right.
Now, Mr. Landman, we've been discussing these non-payment of rent cases and mobile home cases. What is your judgment asking for?
Your Honor, the judgment is asking for possession only, with an order of eviction to issue after August 8th if payment is not made in full. And paragraphs 5 and 6 are checked in the judgment, reflecting that acceptance of partial payment will not prevent the court from issuing an order evicting the defendant. With respect to the propriety of a non-payment of rent action for a manufactured home park, it's specifically permitted, Your Honor, under MCL 600.5714. And I believe that the brief that we've submitted covers all bases as far as how a non-payment action under that statute differs and is distinct from a termination of tenancy action for just cause under MCL 600.5771. They're two separate statutes, and it's apples and oranges, really.
Well, you're evicting her from the lot.
That's correct. We are evicting her from the manufactured home site that she rents. She still owns her home.
I was told I did not own the home.
Well, I don't know whether she has title to the home or not, Your Honor, quite frankly.
I do not. I was told that I still owe $2,000 on the home.
Well, I don't know the answer to that. You may have someone you're purchasing the home from. I'm not evicting her from her house. You can come get a moving company and take the trailer off of there.
That's exactly what, that is exactly the remedy available to my client, Your Honor. That's
All
right.
right, that's what I believe the solution is.
Terribly
and that's
sorry to
very
interrupt, Your
expensive.
Honor.
Yes?
My name is Kyle Evans. I'm the asset manager of Centerville Mobile Home Park. Ms. Poling does not own the home. She is on a rent-to-own agreement with us, where she is paying us $300 a month towards the remaining home loan balance. So technically, the home is still in our possession until that loan amount is paid off.
That's also very common, but this is lot only. This isn't a foreclosure on a mobile home.
It is not a claim and delivery on the home. That's correct, Your Honor.
This is confusing, Ms. Poling.
Very.
Well, the bottom line is you're substantially delinquent in your rent. And
We've been working all the overtime, picking up extra hours, trying to saving all we can.
All right, and maybe you heard me earlier, the whole mobile home market has changed in the last 10 years. And I'm seeing dozens of tenants like you who are getting overwhelmed by the modernization of mobile home parks. They're no longer locally
It's the late
owned.
fees, honestly. It's the late fees that get us every time.
That's not just in mobile homes, that's everybody. Once the late fees start, you get behind, you get farther behind. And we talked about this last time, it just sort of snowballs. But you've got a loan and you're purchasing the mobile home on installments, and you rent the lot. Lot rents have gone up across the country substantially, everywhere, including here. Some of it is good in that they're making some improvements in the properties, and some of it is not good in that the tenants can't afford to live there anymore. But this is lot only. There's a dispute whether they can even do this, but the relief they're asking for, I believe they can ask for. Your mobile home is on their lot and you're behind in the rent, and they're asking you to pay it or they're going to remove your mobile home. Now that may be an idle threat because it's very expensive to remove a mobile home, and the truth of the matter is they aren't very mobile. More than 90% of mobile homes that are cited are never moved again. They're not like, if you don't like it, you can pick up your mobile home and move it somewhere else.
Right.
That's
and
not
this is
very,
an older mobile home.
I'm guessing this probably be very expensive. And plus, where do you put it? You
Right.
gotta move it someplace. So there's
You gotta
another way.
you gotta have land.
Yes. Well, you can't site a mobile home almost anywhere on a single lot. You can no longer take a mobile home and put it out on a 1 acre lot in the country. Most townships won't allow that. They will allow it to move to another park, but almost nowhere will let you site a single wide mobile home someplace. So I said the world is changing, and it's difficult for the tenants. At any rate, Mr. Landman, if you would send me that judgment.
I will email it, Your Honor, to the address that you provided.
All right. Now, Ms. Poling, my advice is you stay in contact with your asset manager and the property manager, Jeshua. You've got two issues. You're behind on your payments on the house, and you're behind on the lot rent. This one is only lot rent. And
Well, see, when I get my statement, it's put together. It's not a separate statement.
let me look. Because if it's a I can't tell that they print these 4 to a page and you can't read the leases. You need a magnifying glass. 4 pages to a page. The date for all this to happen is August 8th, which is 10 days from today. So any payment that you make will be applied to any arrearage that you have. But I told you again, you have to pay the entire amount. And I think it would be easier for them to work out a catch-up plan with you than to try to move this mobile home off this lot.
Absolutely.
So you stay in contact with your manager. And
I actually, the only person I have contact with is Jay Sousa. Any other time that I try to call the other number, I don't ever get an answer or a response or anything like that. And I know that they're out of state as well.
Well, as I said, we had one earlier that are in New York, and the people at our end can't sort it out. And it's accelerating. This was a little bit. Now almost every single mobile home park in the county is now owned by a corporate entity somewhere else. We no longer have local council. We have out of area council. And the world's different, and you can't give them a check or cash. It's a PayPal or Venmo sort of electronic thing. And some people struggle with that. All right. My strong advice is you stay in contact with your manager. If you make any payment in cash, get a receipt. Okay.
Okay.
Do you have any questions?
So we're able to go make a partial payment at after court?
Yes.
Okay.
All right. Best of luck to you.
All right. Thank you.
Thank you, Your Honor. Have a great rest of the day. That's our only case today.
This is a work in progress, and both you and Mr. Popovits appear all over the state. But the district judges have been discussing this. Probably going to discuss it again in a couple of weeks at our district judge conference. But we need some help. We need them either to fix the statute or get a court of appeals opinion that tells us what the answer is. But I think the relief you've asked for, where you move the mobile home, is the remedy. But it is confusing when you have a rent to own on the mobile home and lot rent. And this lady could benefit from some legal counsel, but we'll see where this goes. All right. I'll go back and struggle with our last case, but I'll see you guys next time.
Thank you, Your Honor.
Thank you. All right. Mr. Popovits is back. Let me close the breakout room. Miss Enzeldua is back. We finished the Centerville case. Joshua, you're free to go on about your business. All right, Mr. Popovits, where are we now?
Thank you, Your Honor. First, getting back to the conversation and your reflection on that mobile home issue, I do find that
ED as ordered on February 1st, 2024.
Ms. Smith, do you understand those allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you. Do you have the funds to hire an attorney?
I do not.
Do you want me to appoint you one?
Yes, please.
Mr. Mall's handing you an affidavit of indigency that you need to sign.
Okay. Right above my name.
Why is she not in custody?
Your Honor, Ms. Smith, despite her non-compliance with court orders, she has continued to drug test negative. And she has appeared for order to reports after they were issued.
Thank you. All right, the court will find that you're indigent for the purposes of retaining counsel. The court will appoint Attorney Roger Bouchard to represent you in this matter. Court finds that there's probable cause you have violated the terms of your ILC, and this matter is going to be set for final hearing. Ms. Smith, I don't know what you expect. Looking at your record, this isn't your first contact with the court, but I'm not sure what you've expected or what you have done in other courtrooms, but this is very different. I'm going to hold you to what I ordered you to do.
Yes,
So
sir.
you owe significant amount in restitution.
It's $11,433.
You have been on ILC for over a year. You have not done anything, and you continue to break the law. The next time you appear before me, you better have a solid plan in place, or you are going into custody. Do you understand me?
Yes, sir.
You owe $11,000 to the victim in this case. You don't seem to care that I've ordered you to do things. You come to court dressed very inappropriately. And I'm telling you right now, I don't know what your contact with the court has been in the past, but it's going to be different when you come in here to see me again. Do you understand me?
Yes, sir.
Because the next time I see you, if you haven't done something, you are going into custody. Are we clear?
Yes, sir.
All right, that's all.
Interesting. I do represent not quite as many mobile home parks as I do apartment complexes, but I do work, as you mentioned, all over the state. And I remember another, I think maybe that case or a similar case in front of you the last time I was in front of you. So I do, and I agree. It's a curious topic for sure. In any event, as it relates to, I appreciate your take on it because I think of the curious nature of it as you move forward with those types of cases. With respect to Enchanted Glen, I've went over the ledger with my client, and listen, we reflect or regard, we understand there's some confusion regarding the amounts. So what I'm prepared to do today is going back to your math. So on May 20, it's May, the complaint was signed in May. There was $283.14 due and owing. Rent was reflected as $143 a month. That means another $286 is due through July, plus $20 in late fees. That's a total of $589.14. What's clear from the ledger consistently is that Ms. Anzadula did pay the $490. That brings the total amount due for rent to $99.14. We also would ask that the court cost, the $229, be, let me pull that up just so I have that for the court's record. The $90 in filing fee, the court's mailing fee of $13, the service fees of $44.69, and the attorney fee of $75, $222.69 due and owing. We'd ask that the judgment be for the $99.14 in rent, along with that $222.69 in court costs. We'd ask that she have 10 days to pay that amount. Ms. Anzadula, you're involved in a situation that gets kind of confusing. for both property managers. This Ms. Shaw, who's new, comes into the property. This is different than a privatized landlord where your rent remains the same every month. There are some issues here because of your recertification, and they are complicated when you don't pay, meaning that your recertification has been stagnant because of the non-payment action. So what we're going to do is, if the court is so kind to grant the judgment for these amounts, because it's the most fair resolution for you today, I wanted to at least, and I told Ms. Shaw that I would say this on the record, it's imperative that you, to remove this $940 charge that's been reflected on the ledger for retroactive increase of market rent, that once you pay this amount under the judgment, I'll work with my corporate contacts. Your recertification will be allowed to go forward. You'll need to sign that. There will then be a revisionary history as to reducing your rent from the market rate back down to the subsidized rate. There will be a reconciliation of your ledger. There may be some accounting issues or some payments that may be required at that point. That will be handled and finalized once the recertification is finalized. And then that will be explained to you so you can have some opportunities to make arrangements for those payments. Your Honor, if we find ourselves back in front of you in the future after she's paid this and after the recertification, Ms. Shaw and I will come that day with a ledger that we are ready to dissect and explain to you on the record, and Ms. Anzadula as well, so there's no confusion. In the interim, though, we hope that the court will agree with that this is a fair resolution given the form of the pleadings and the ledger and what information Ms. Anzadula would have had before today. And we'd ask that we have a judgment for the amounts previously set forth and move forward in that fashion.
All right. What was the amount again through July?
$99.14.
All right. That's a substantial change. The total of that. $321.83.
Are you completing
Ms. Hansel, do it? What?
Just a clarification. Do you want my office to submit a judgment, or were you completing?
Please, no, they do things differently in different courts. My preference is to have the judgment in front of me. And I guess I should start. My local attorneys all give me a judgment, so I can do it right here and hand it to the people. And I haven't been vigorous enough about getting the out-of-county counsel to give me one. But yes, so Ms. Anzaldua, let's break this down. After we did all the calculations, we determined that your rent through July is $99.14. August 1st, you're going to know another month's rent. The court cost is the filing fee, the service fee, the mailing fee, and the attorney fee. That's $222.69. So you owe $321.83. And you have until August 8th to pay that. Then you got to pay August rent too, August 1st. You need to go into the office and do your recertification. Once you pay the rent, you can get recertified, and they take that $940 market rent charge off of there. Can you pay $321.83 by August 8th?
I should be able to. I can actually pay $260 today.
All right, well, that's a great start. All right, the date for the writ is August 8th. Partial payment will not prevent the writ of eviction. You have to pay the entire amount. And Mr. Popovits, I'd ask you to email me a judgment.
Yes, Your Honor. And just from
Yes.
Oh, I was just for clarification. The judgment will reflect that partial payments will not stop the issuance of an order of eviction. So Ms. Anzadula just mentioned she's got an amount to pay. I wanted to clarify with her, the standard form would be that partial payment. So if you're going to pay that, it's fine, but just know that the full amount that's set forth in the judgment would need to be paid, and partial payments could end up being forfeited as to an eviction order. But it sounds like, I mean, we're at an amount that hopefully is feasible, and you'll cure it and move forward with the recertification.
All right. Do you have any questions?
Just the exact amount I owe.
Well, you owe $99.14 plus $222.69. for a total of $321.83 through July.
Okay.
And you owe $143 for August. Now, Mr. Popov has mentioned this. There may be some other fees in here that they aren't part of this judgment. If you pay this, it will forestall an eviction. Then we can figure out what's what, and get squared away as of August.
Okay.
All right, $321.83. $260 will go quite a ways to paying that off, but you have to pay the whole thing to cure it.
Okay.
All right, I'll await that judgment and we'll send it to you when I get it.
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
Thanks.
Thank you, Ms. Shaw. Take care, everyone.
All right.
Thank you.
All right, we're getting down to the home stretch here. I apologize, Mr. Buckland. I kicked you out when you still had another case to go here, but let's call Michael Mullet versus Donna College. Mike is here. Defendant was here last time by telephone only. This is file 251299LT. I assume that is Michael Mullet. And Mr. Buckland, what's the situation here?
Judge, I have a note from the last pretrial just indicating the tenant was looking for a place to move to. I have the current numbers as far as the rent and cost. My understanding is that there is $5,764 that's owed. There are $179.10 in costs for a total of $5,943.10. And so I suppose if the tenant has failed to appear today, we would move for an entry of a default.
And I would grant that those numbers are the same as we had last time. And again, I don't think I have a judgment here. If you would email me one.
I will do so, and I'll make a note for my assistant judge. Just practicing in different counties, judges handle it different. Branch counties went to where they just prepare the judgments, themselves. And so, if your preference is to have the attorneys do it, then we'll certainly make note of that.
That's interesting. Yes, way back to Judge McManus's days, the attorneys did them, and maybe you're right. They different in different places, but our attorneys will give me a judgment. Occasionally, I'll do one with a proper landlord that doesn't know what they're doing, but she knew the amount due. I think that she's going to be unable to pay it. She simply is going to have to move, and I'll await the judgment.
And then just for the record, it looks like the monthly rent is $750. And so another $750 would be due on August 1st before the writ date. So I'll just put in the further order section that an additional $750 would be due on August 1st for rent if it wasn't paid prior to that.
All right, that should cover it. I was doing it. I was adding it in. We had a judge conference. About half of the judges were adding it in. Half said you couldn't do it. So in fact, during COVID with the grant money, I was doing it all the time. So if another month was going to come before the writ date, I put the other month in the order, and nobody objected, including legal aid, because then it was clear that I would pay their rent through August. Well, then at some point they objected and they appealed, and Judge Stutzman made a ruling that I cannot include that subsequent month's rent because it isn't yet due. So that's the current state of the law, at least here in St. Joe County. But I think that notation on that line should explain it. All right. Thank you very much.
Yep.
I'll see you next time.
Okay, thank you.
Thank you. Well, our next matter is at 11:30. It's another bumpy one. Every single case today was a second hearing. It was hours ago.
Oh,
Who was her landlord?
I don't know, sir. She just said that she had the same meeting thing from last week and she couldn't join. And I said, nothing's changed. And she said she'd try it again. So I don't know, maybe she thought it was for the same time as last week. Or whenever it was.
It was set for 11 o'clock. She wasn't here. Anyway, here's the judgment. She's gonna have to move. She owes $6,000.
Okay, and she calls back, I'll let her.
All right, thank you.
And I can take these.
Yes, thank you. Mr. Worthington, are you there?
Yeah, I'm here.
All right. I'm waiting for the landlord to log in.
Okay.
Here they are now, I think a minute late, but not too bad. I'm not sure who this is. Miss College, is that you?
Yes, it is, hon.
All right, well, you're half an hour late for your hearing. We had the hearing at 11 and,
Oh, crap, I had it down for 11:30. Crap.
no, it was at 11 and you have till August 8th to pay $5,900 in rent and court costs. What you
Yeah, I
expressed
did.
last time is you were gonna be looking for a place to move to.
Yeah, and
So-
I also called DHS and it is pending, but they had to throw it over to the supervisor because there's a $1,200 charge or a minus.
I'd be amazed if they'll pay that much rent, but as soon as you get the judgment, you share it with DHS.
Okay.
All right, otherwise
do you
you may
got
need to
my-
plan to vacate by August 8th.
Okay, do you got my mailing address?
Yes, we do.
It's the 700 Riverside Drive.
I believe that's the address on the lease.
No, the one on the lease is for here. And I don't get mail here in Pigeon.
Oh, 700 Riverside Drive. Michelle, would you make a note of that? Riverside Drive, what town?
Constantine.
Okay. All right, yeah, we did the hearing at 11 and we were surprised you weren't there, but the attorney's gone. He's already sent me the judgment. You owe a lot of money. If you can't pay the entire amount, you're subject to being evicted.
Yes, I know this.
All right, I'll send you that judgment.
My boyfriend's sister Barb's gonna help us out with it, so.
All right, very good. Hopefully that'll help you get squared away.
Okay.
All right. Well, I'm going to call this case Yesenia Sanchez Ramos versus Steve Worthington. This is a second hearing. We were here on July 16th. Mr. Worthington was here. He wants to stay there. He was getting mixed signals from Yesenia, who's the actual owner, and his husband Santana, her husband Santana. But the bottom line is they don't have a lease and the plaintiff wants them to vacate. Mr. Worthington, have you had contact with your landlord?
No, sir.
Yes, I did.
Oh, my wife did.
All right, tell me about that.
I was texting him after court and he sounded like he was gonna work with us, said he was gonna talk to his wife, and then I haven't heard
Just a minute.
anything.
She's here now.
RIA.
Good morning.
At
Good
Can you hear me?
Yes.
You're late for your own court hearing. We've been sitting around for 4 minutes waiting for you to show up. We try to do these on time. When we were here last time, you had expressed that you wanted the tenants to move. They're getting mixed signals from your husband. And there is no lease. What's your preference at this point, Ms. Sanchez Ramos?
I just want the people move out.
Okay. Yes. Yes.
All right, what I told you last time, Mr. and Mrs. Worthington, I'll repeat. If you move somewhere else, you need a lease. And Ms. Sanchez Ramos, if you're gonna continue to rent these, you need a lease. But you don't have a lease and she's the owner, not Santana, and she wants you to move. You have until August 8th to vacate or you're subject to being evicted. You
Yes,
have
sir.
until August 8th.
I have a question.
Just a minute. I'm not ordering any money damages. I'm simply ordering that you move by August 8th. If they're gonna sue you for money, that would be at a separate hearing. What's your question?
I was wondering if I could have until the 10th so I can have everything out and have the apartment cleaned.
Well, they can agree to do that. August 8th is a Friday. As a practical matter, they probably can't get the writ till the 11th anyway. But if you vacate by the 10th and everything's clean, you should be all right.
Okay, thank you.
All right, now, when you move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease, so I don't even know if there's a security deposit or anything, but.
Yes, sir, I paid security deposit.
Okay, then this is about your deposit. You need to turn in the keys and give your forwarding address in writing within 4 days of vacating. And if you're out by the 10th and everything's clean, then maybe that won't be much of an issue. All right, do you have any other questions?
No, sir, they'll get a P.O. box address for the moment.
Okay, make sure he has that. Ms. Sanchez Ramos, please try to show up on time. We get kind of jammed up. This happened to be the last case of the day, but we'll be all right. All right, everybody's good.
Do I have to turn in the address to you, sir?
No,
Besides
turn it
them?
into your land. The P.O. box would be sufficient for a mailing address. All right, good luck.
Judge,
Hey,
this is live on YouTube.
no, it's not. I'm trying to shut it off. I shut off the courtroom. And I
I'm
removed,
looking at it.
it's on YouTube right now?
Yes.
All right, I shut down the courtroom. Let me look again. Yeah, my button didn't work. Is it off?
No,
It's not?
no.
We've had all
Probably gonna have
kinds
to
of
shut-
technical problems this morning.
We may have to shut
it's
everything
shut down
down.
in the courtroom, obviously. Is it shut down now?
No.
All right, well, I'm gonna close this and reopen it.
Okay.
So try again in about 5 minutes. I can't figure out what's going on. Obviously we can't live stream our session.
On the Samsung device, can I get your name, please?
Can you hear me?
Yes, I can. What's your name?
Robert Gilbert. My phone died on me. I had to get a different device.
Okay.
Hamptons versus Chelsea Tavalette and Asia Jackson, 2502590.
Judge, give me 1 second. You're moving faster than me.
All right, Ms. Jackson, could you tell me your name, please?
Yes, Asia Jackson.
Ms. Tavalette, your name?
Let's go play in your room for a little bit.
Chelsea Tavaletti.
And do I have, okay, Ms. Austin, good afternoon, your name?
Rebecca Austin for plaintiff, Your Honor. Good to see you.
And Your Honor, Alexa Metner on behalf of Miss Jackson.
Okay, and you filed an appearance, correct?
Correct.
Ms. Tavalette, did you listen to and understand all the rights on the video?
I did not receive a video.
Judge, this was a second hearing, so I didn't. Was she not here last time? I apologize. I didn't have that note.
All right. All right. You understand, ma'am, that you have the right to a lawyer in proper venue and the right to a jury trial. If you want one, you have to request one within 5 days. You have the right to apply for funding with the Department of Health and Human Services, the local coordinated entry agency, HERA, or the Federal Help for Homeless Veterans Program. They may be able to assist you with payment of some or all the rent due. The summons and complaint are sufficient. There's also the possibility of a conditional dismissal if all parties agree. Do you understand that?
Yes.
Okay, you just have to keep your voice up. Do you wish to speak to a lawyer, ma'am?
Not at the moment, no.
Do you intend to apply for funding?
Your Honor, the other defendant, we filed a DC 539 form for funding.
Do you, Ms. Tavalette, intend to apply for funding?
No.
All right, so have you heard anything on that application? Has she submitted proof to the court?
We did submit a DC 539. We're still waiting to hear from SCR. She might have some availability or some money coming from a church if she can get the balance down. And then the other co-defendant is just a co-signer. She doesn't live there. That might be why she's a little hesitant, but that's why I'm representing Miss Jackson, and we filed the rental assistance form in her name.
Okay, so she's entitled to a 2-week adjournment. What do you have, Jennifer?
Judge, we've got August 4th through 11th, which.
The 11th at 8:30?
9:30.
9:30. Okay, August 11th at 9:30. We'll see everybody back here. Anything else, Ms. Smetner?
That's all, Your Honor.
Ms. Austin?
Thank you.
You commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. And that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes.
But it's not mandatory that you're sent to prison at all. The court does have the discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they must find you not guilty, and their verdict has to be unanimous. Do you understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes.
This is how you wish to proceed?
Yes.
All right. Ms. Tranter.
On or about October 28th, 2024, Warren County, State of Ohio, the defendant, Michaela Wells, did with purpose to deprive the owner of property, knowingly exerted control over that property without their consent. This was a theft from Ulta Cosmetics in Deerfield Township. The amount of the merchandise was valued at $2,483.
Mr. Niehaus, anything on those facts?
Waive and stipulate.
Ms. Wells, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes.
What is your plea?
Yes.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Ms. Wells, I know you didn't come down here today this was an ILC hearing, so I am going to allow Mr. Niehaus to schedule this at his convenience over the next several weeks. Now, just so that we're clear, you are 18 years old. You have theft charges pending in Butler County, Cuyahoga County. You're on probation in several counties for theft offenses. This is not a good start to your life, adult life, I should say, is it?
No.
So either you stop stealing or you're going to spend the rest of your life in and out of jail. And I don't know how to get through to you. I appreciate the fact that you were here on time. In fact, you were here early today. I told you last time you needed to be more respectful with regard to that, and you responded. but then you still testing positive for marijuana, which I told you you were not allowed to use as a condition of your bond. Now, between the time between the time of now and the time that you come back for sentencing, there's a couple of things that I would recommend to you if you don't want to go to jail. Because quite frankly, I don't like people to come into my county and steal from other people. Have you ever had something stolen from you?
Yes.
It's not a very pleasant thing. Something that you own, that you've worked for, that you've earned is taken from you by someone who did not earn it. That's very bothersome to me. So there's several $1,000s in restitution that's owed. If I were you and I didn't want to go into custody, I would do everything I could to get that restitution paid in full before I came back. And I'd stop smoking marijuana because the judge told me I wasn't allowed to do it. That's just me. You can make your choices. You're now an adult. But when you make bad choices, you understand there are consequences. We clear on this?
Yes.
All right. They're just giving you some advice to maybe keep you from going into custody because quite frankly, at this point in time of your life, you're not in juvenile court anymore. The consequences are more severe. And in this county, I will hold you to those consequences. Okay. I don't know what your experience is in Cuyahoga County where I don't know if they forget about you or what. I'm not going to forget. Okay.
Yes.
All right. Do what you got to do. I'll see you in a few weeks.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Mohammed Khan versus Sarah Massaro,
Yes, sir. Mohammed here.
2502704. Okay, you have to state your last name too, sir.
Mohammed Khan.
Is Sarah Massaro here?
No, Your Honor.
All right, Mr. Khan, how much is owed in just past due rent right now?
May, June, July, 3 months, $1,500 a month. So that's
It does not include any late fees, correct?
no, I don't charge her late fees because she had
$55 filing fee. How much did you pay for service? Do you know?
$40, I believe.
$44.70.
$44.70.
$44.75. Do you have any other out of pocket?
Yes, sir. She did leave so much stuff. You know, she just took her appliances with her. She actually started moving
Slow
down.
down. Slow down. You haven't been into the apartment, right? Because you couldn't be because did she turn over the key to you?
Yes, sir. What happened was she started moving about 5-6 days ago. She's been taking most of her stuff.
Did she give you the keys?
Yeah, she did.
You have the keys?
Yeah, she just left. She said,
Listen to my question. I want to be clear about this.
Okay.
Did she personally hand you the keys? She didn't, did she?
She
She didn't hand you the keys, did she?
well, sir, she left the door open for me to go
Sir.
inside.
I don't know what that means. I leave my door open sometimes. I don't know what that means. I can't give you, you cannot go into that unit, sir, until you've got a judgment and the writ date's expired or she's turned over the keys. You don't have the keys, right?
No, she didn't personally hand me the keys.
So you can't go in there. You understand me?
But she's all moved out.
Sir?
Okay.
You go in there and I find out about it, you're gonna have a big problem with me. Okay?
Okay.
A massive problem with me. Do you have any other out of pocket?
No, that should be good.
You didn't pay any,
There was a water bill, $50 a month, water bill.
how much does she owe in water bills?
$150. I just charge her $50 a month.
Slow down. $150?
For 3 months, yes.
You understand you can't get a money judgment, right? This is just for possession.
Okay. Do I have to file some more paperwork for money judgment?
You do. And you should consult with a lawyer. I can't really give you advice.
Okay.
But I'm going to give you a default on this.
Okay.
Now, your writ date's going to be August the 8th. So if she doesn't pay $4,749.75 on or before the 8th, you can submit an application for a writ. Jennifer, are you going to do that judgment?
Judge, I have it here. I'll just have to get the numbers again.
So that's the way it is. I'm giving you a possession judgment only, not a money judgment.
Okay.
Possession judgment only, meaning she has until the 8th to pay up or vacate. If she doesn't pay up and she doesn't vacate, and by vacate, I mean handing you the keys, then you have to come in here on the 11th, which is a Monday, and submit an application for a writ. Okay?
Okay, thank you, sir.
All right, you're all set. Good luck.
Okay, thank you. Thank you.
Meadowlands versus John Bro, 2502854. Meadowlands ready? There you are. How are you?
Good afternoon, Your Honor. Brandon Kingsley appearing on behalf of the plaintiff.
Is John Bro here?
I've not had him check in, Your Honor.
And they paid for a second mailing. You could take a default.
Your Honor, in light of the defendant's failure to appear, I would request entry of a default possession only judgment. Rent to retain $1,551.69. Late fees are $80. That's $40 for 2 months. Court costs $184.17. Total $1,815.86 with a writ to issue in 10 days.
Defendant failed to appear. Default judgment letter. Writ date will be on August the 8th. The amount to be paid to save it from the issuance of the writ is $1,815.86.
Thank you, Your Honor.
Meadowlands versus Christina Kaliba, 2502858. Is Christina Kaliba here?
She is not checked in on Zoom, Your Honor.
All right. You can go ahead and proceed with the default on this one.
Thank you, Your Honor. In light of the defendant's failure to appear, I would request entry of a default possession only judgment. Rent to retain $1,471.78. Late fees are $120. That's $40 at 3 months. Court costs $184.17. Total $1,775.95 with a writ to issue in 10 days.
Defendant failed to appear. Default judgment winner. Writ date will be August the 8th. The amount to be paid to save is $1,775.95. Can you please try to get me those judgments here in the next 10, 15, 20 minutes, if you would?
Yeah, I can get them uploaded to my file.
All right. Thanks a lot. Do you have any more?
I do. I have Woodhaven Place. I have a few for Woodhaven Place.
Okay. Williamsburg versus Stephen Hall, 2502865. Mr. Hall, your name?
Hall.
I'm sorry. Say it again, please.
Stephen Hall. Can you hear me?
Yeah, now I can. Ms. Austin?
Rebecca Austin for plaintiff, Your Honor.
Did you listen to and understand the rights on the video, sir?
Yes, I did.
You wish to speak to an attorney?
No, I do not.
Do you intend to apply for funding?
No, I actually submitted a 30-day notice to the office that I would be moving out by the end of August.
Well, you're gonna have to do, okay. Well, wait, this is for non-payment. You don't get to the end of August. How much is owed, Ms. Austin?
Your Honor, the total owed is $2496.08, but if he's gonna move by the end, it looks like by the end of the week.
August.
In July. When are you moving, sir? End of August?
Then, well, they told me the end of August, but
yeah,
I mean, I can get out sooner. Within a week.
Hang on one second. Can you give me your breakdown, Ms. Austin?
I can, Your Honor. Past due rent, $2,179.54, $270 late fees, so $140 in late fees, so that subtotals $2319.54. Court cost of $176.54 for a total judgment of $2496.08.
So, sir, can you pay that by the 8th?
Oh no, I can't. No, yeah, that's why I got a. I've been in front of you 3 times in a year. I just got to face facts. I can't afford to live here anymore. I gotta make some changes in my life and get myself in a better financial position. That's why I told him I would be moving.
Well, you're gonna have to move by August 8th or you're gonna have to pay that, okay? I'm giving them a writ date of August the 8th, so you have about 10 days. And if you don't move out, they're gonna submit an application for a writ and you're going to be evicted. So you either have to pay up or move out by August the 8th, and the total's 249608, okay?
Okay, then once I have everything out, just go to hand them the keys.
Correct.
Okay.
Correct. Okay?
Okay.
Wish you well, thank you. Do you have any more, Ms. Austin?
Your Honor, have a great afternoon.
Hey, you too. Thank you very much. Woodhaven Place versus Daryl Anderson, 2502883.
Brianna Kingsley for the plaintiff.
Mr. Anderson, your name?
Daryl Anderson.
Sir, did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
Not at this time.
Do you intend to apply for funding?
Not at this time.
Why don't you just tell me the total amount?
$3,590.56.
Can you pay that, sir?
I can pay the full balance due by Friday.
Okay.
Is that going to include August, because August is going to come due on Friday?
No, I would need at least a week and a half, 2 weeks to make August payment.
Could you pay the balance plus August by the 12th?
By the 12th? No, I would need to the following Friday, which is what, the 21st or the 22nd? Or,
okay.
I'm sorry.
The 22nd?
You said you could pay it in 2 weeks, didn't you?
Yeah, 2 weeks from now I could pay plus August, but I can have what I currently owe paid Friday.
Yes, and then you can have August by the 22nd?
15th.
By the 15th or the 22nd?
The 22nd.
Okay, Judge, it sounds like we could just do a consent judgment today for the balance by,
I'm gonna do it as a judgment after hearing. If defendant pays 3590.56 by August 7th, writ date extended until the 22nd. So you have to pay that by the 7th. The writ date would be the 8th. So you're gonna put the writ date down as the 8th, counsel. If defendant pays 3590.56 by August 7, writ date extended to August 22. So you have to pay that by the 8th. But if you don't pay the 3590.56 by the 7th, you have to vacate on the 8th.
Okay.
Okay.
Yeah, I'll have the
3590.56 by this Friday, you said, right?
Yes.
So as long as you do that, you got until August 22nd. If you don't pay by the 7th, you have to have all of it by the 8th.
Understood.
All right. Good luck to you. Thank you. Woodhaven Place versus Jeffrey Brown, 2502884.
for the plaintiff.
Is Mr. Brown here, Jennifer?
I did not have Mr. Brown check in.
All right. They paid for a second mailing. You can go ahead and proceed with the default.
Thank you, Your Honor. In light of the defendant's failure to appear, I would request entry of a default possession-only judgment. Rent to retain, $1,836.02. Late fees are $140. That's $70 for 2 months. Court costs $178.54 for a total of $21.54.56 to be paid within 10 days.
Defendant failed to appear. Default judgment entered. Writ date will be August the 8th. The amount to be paid to save it from the issuance of the writ is $21.54.56. Woodhaven Place versus Diane Gilbert, 2502885.
Brianna Kingsley for the plaintiff.
I don't see Ms.
I think Robert Gilbert, I believe, is Diane's son.
Yes, Miss Gilbert is deceased and her son is, I'm just trying to get him to unmute.
Mr. Gilbert, you have to unmute. There you go. Your name?
Robert Gilbert.
All right, so he's another occupant. Is that right, Ms. Kingsley?
Yes, correct.
All right. Sir, did you listen to and understand the rights on the video?
When I was watching the video, my device died, so I ended up getting on a different device, but I plan on making the payment.
You have the right to a lawyer. You have the right to proper venue. You have the right to request a jury within 5 days. You have the right to apply for funding with a variety of different agencies. The summons and complaint are sufficient. You don't need a judgment. There's also the possibility of a conditional dismissal if all parties agree. Do you understand that?
Yes.
Do you wish to speak to a lawyer?
No, thank you.
You intend to apply for funding?
No.
All right, give me the total amount that's due, Ms. Kingsley, no breakdown.
$1,964.28.
Do you, when can you pay that, sir?
I would say by Friday.
What do you want me to do, Ms. Kingsley? You want a judgment for the 8th?
Yes, please.
All right, give me your breakdown.
Rent to retain, $1,645.74. Late fees, $140. That's $70 at 2 months. Court costs, $178.54 for a total of $1,964.28.
All right, so sir, I'm going to give them a judgment after hearing. You have to pay that amount no later than the 8th of August or you have to vacate, okay? So if you give it to them this Friday, you're all set.
Okay.
Okay, any questions?
No, sir.
Best of luck to you. Thank you.
Thank you.
William Place versus Heather King and Fina Woodruff, 2502886.
Anna Kingsley for the plaintiff.
Ma'am, your name?
Heather King, and my mother is Finna Woodruff. She is getting my son off the bus. He's special needs.
Did you listen to and understand the rights?
Yes, I did, Your Honor.
You wish to speak to a lawyer?
No, Your Honor.
Okay.
Intend to apply for funding?
Not at this time, Your Honor.
All right. So Fina Woodruff is not here, so if we resolve this today, that's going to be by default.
She is here. She's just outside. My son is in a summer school program. He's getting ready to get off the bus. He's special needs. I can get her if you.
Well, let me see where we go with this, okay?
Thank you.
Tell me the total amount that's owed, Ms. Kingsley.
$2,170.82.
You agree that you owe that amount?
He's getting off the bus now, pardon. I called yesterday. The office said it was $2,200 and $2,211 even.
Well, they're cutting you a break. She
Yeah.
said 17082.
That's with the adjustment per the court's policies of late fees, Judge.
Yeah, I only give 70 a
Yeah.
month.
So
You
that's with
guys
the
are
adjustment.
gouging for worse than that, huh?
85 per month per the contract, but I do manually adjust them per the court's
I'm just
requirement.
kidding. I'm just kidding. Give me the breakdown.
Rent to retain, $1,812.89. Late fees, $140. That's $70 for 2 months. Court costs, $217.93. Total, $21.70.82.
You're going to be able to pay that, ma'am, between you and your mom?
Yes, I spoke with Kathy at the office yesterday, and it's going to be tomorrow. That's when my last deposits are going to be to get it caught up.
The full
Okay.
balance.
So, ma'am, I'm just going to default your mother. Don't panic. It's no different. I'll enter a default judgment against her, judgment of possession against you. You have to pay $2170.82, and the writ date will be on August the 8th, okay?
Okay.
So as long as you pay by then, you're all set.
Oh, it's going to be tomorrow, thank goodness.
I understand. Okay. All right. Do you have any questions?
No, not at this time, Your Honor. Thank you.
I wish you well. Good luck.
Thank you.
Thank you.
Your Honor.
So that will be by default versus Fina, okay?
Sounds good. I'll mark it appropriately.
All right. Now I have Woodhaven Place versus Kristen Wiesen, 2502888.
Brianna Kingsley for the plaintiff.
Is Wiesen your name?
I'm Kristen Wiesen.
Good morning or afternoon. Did you listen to and understand the rights on the video?
Yes, Your Honor.
Do you wish to speak to a lawyer?
Not at this moment.
Do you intend to apply for funding?
Not at this time, no.
Ms. Kingsley, can you tell me how much is owed? Why don't you give me the breakdown?
Yes. So the total balance due, just to clarify, is $1,279.19. She did submit another payment of $410. That has not been applied to that amount. So what I have currently is rent to retain in the amount of $960.65. Late fees of $140, that's $70 for 2 months. Court costs $178.54 for a total of $1,279.19.
So, ma'am, if you paid, you said 410, did she pay?
Correct. So the remaining balance would be $869.19. I just don't have confirmation that it's been posted to the account yet.
Why don't you include on further orders, defendant has tendered 410, which is not included in the above balance. How's that?
Yeah, I can put will be applied to the amount in 2D upon confirmation. Yeah. That's
Ma'am,
fine.
do you have the money to pay this?
I do not at the moment, but I'm working and I make about $600 a week. So I was estimating I could give them about $500 a week for, and I know August is about to hit, but that was my plan, is to keep going with giving them around about $500 a week to catch up.
Without August, if you pay $500 this week and $500 next week, you'll be paid in full for this amount, right?
Okay. Yes.
So can you pay by the 8th?
Yes. I'm pretty sure. Hold on. What
Not
is today?
including August.
Is the
We're
20th?
just talking about, yeah.
Okay. So is that 2 weeks from now?
So I'm going to give him a judgment. That's a week from Friday. So you'd have to pay $869.19 by Friday, August the 8th. That's a week from this Friday.
Okay. Thursday and okay. Oh yes, I should be able to get the 2 500s will cover what I owe right now.
Correct. That'll get you covered through July, and then your August rent will come due as well.
Okay. All right. Yes, that'll be.
Can you do that, ma'am?
Yes.
So we'll do this after hearing. Again, the writ date, you have to have all that money paid by the 8th, okay?
Okay.
All right,
All right.
any questions?
Yes, Your Honor. No, thank you, Your Honor.
I wish you well. Ms.
Thank you so
Is
much.
that it?
That's it, Your Honor. I will get those judgments uploaded.
Thank you very much. Have a great day.
Thank you.
Thank
You too.
you. Where's the rest of mine?
We have 3 left. On the iPhone, can I get your name, please?
Way to go.
Crystal Thomas.
I'm just messing.
Okay, Miss Thomas, you're scheduled for 1:30 or 1:30. I'll get you in to show you the video.
Okay.
Judge, I've just got 3 more that I'm waiting to check in, and then we will have the 1:30s ready.
No problem.
I did send all of those judgments that have come in and dismissals down to you as well.
Okay, perfect. So where'd you guys play at? What? Where'd you play?
Sure. Killed it. I was hitting good.
Were you? Yeah. Maybe you should go play for me.
Might have to.
No, thanks.
Where
Miss
you?
Thomas, if you can join the breakout room. On the iPhone, can I get your name, please?
I thought I figured something out on Saturday and I played yesterday and
On the iPhone, can I get your name?
John Pitts.
Thank you, Mr. Pitts. Let me get you renamed. I'm going to move you into a breakout room so I can show you a video in just a moment, okay?
Okay. Thank you.
Mhm. You're going to be in there with someone else. Don't panic. I'll be in there in just a moment.
Okay.
if you hunt. Good.
1200. Legit 12.
You guys went.
Nothing. They don't get nothing same place.
Miss Morris?
Is that what it?
Tamisha Morris?
Yes.
What are you appearing on this afternoon?
Yeah, but she lost weight over, right?
The Bobby Bell and Tamisha Bell.
Okay, we received a dismissal, actually just a short time ago.
Oh, I didn't know. Okay.
Yeah, we just got it electronically.
Okay. All right.
Okay.
Well, yes, ma'am. Are you,
All
are
right.
you guys gonna send me something?
Once the judge signs it, we have to have the judge sign first, and then you'll get a
Okay.
copy.
Okay. Yes, ma'am. Thank you so much. Have a
You're
good
welcome.
day.
You too. Bye now.
That's some stuff for you to sign.
Judge, I'm going to go show these to the video, and then we'll be ready.
This has probably got me all logged on base.
I can.